broadcast online and throughout Parliament buildings. And just to welcome anybody watching online, if phones can go on to mute, please, and no photography during the meeting, please. Okay, so we're going to proceed with the agenda. And in terms of apologies, we have apologies from Claire, and we have Emma Sheeran online, and I think Padraig's going to join us soon. And I think Sinead, I have seen her in the building, so I think she'll be here shortly. So in terms of declarations of interest, does anybody have any to declare? No? Okay. So in terms of chairperson's business, we don't have any this week. So draft minutes are found on pages 7 to 11 of your meeting pack, and I would ask if you're content that these are a true reflection. Yeah, okay. Welcome, Padraig. Padraig Delargy is now online. Okay, so in terms of matters arising, Carol, did you have?
I did. It was just under the equality gaps inquiry. Yes. I remember before raising the potential for CAJ to come. Have they been asked to come front of the committee, or what's happening?
I was thinking of inviting the Equality Coalition, which is sponsored by CAJ.
Yeah, but it was really on the screen, and it was on the back of the presentation that we received from the Equality Commission and Human Rights Commission that day. Mm-hmm. Okay. It was something completely separate, and I mean, they could certainly go in with that, but it was just on the whole screening issue. Thank you.
Thank you. So just to pick up on that point, yes, so the clerk's brief on the inquiry planning gaps in equality legislation has been updated further to our conversation last week. So just to seek your agreement, members, in terms of the draft terms of reference, the tasking, the assembly research, the list of witnesses for written evidence, and also a list of witnesses for oral evidence, and then potential visits, if any, and then the timescales. If people had an opportunity to look at those, I thought they were...
Yes, I thought they were quite broad, but I would also ask that even submissions from the neighbourhood renewal partnerships,
yes. Mm-hmm.
Because, I mean, like, these groups are really representative and do great work, but underneath the skin of that, there's that work that goes on at grassroots.
Okay, good job. Okay, they've taken a note of that. Okay, thank you. Okay, members, so I'm going to refer you to page 17 of the pack for the HIA Redress Board Annual Report, and page 3 of the table pack for the HIA Redress Board Key Performance Summary Report 2023 to 24, and to advise you that these documents provide answers to committee queries from last week's meeting on the Redress Board legal fees up to March 2023, and the number of claims that have been rejected or discontinued, i.e. they're over 1,000 by the end of 2023. And I suppose the issue that did come up last week, that I have for the departmental officials, is why they didn't include those figures in the packs. They told us some figures, but they didn't give us everything. So appreciate that we've now got that information. Okay, members, so we're going to move on to our first oral evidence session, and I refer you to page 31 of the pack for the clerk's brief and page 33 of the pack for the departmental brief. So I'm going to welcome to the meeting Gareth Johnston, Senior Responsible Officer at the Executive Office, Martin Carey, who's the Programme Director, Executive Office, Michaela Jordan, Programme Manager, Executive Office, and Pauline Corskadden, that's right. Thank you. So Programme Team and Secretariat at the Executive Office. Okay, so we've got 3 panels today, so I would appreciate if you could keep your opening remarks brief. But over to you. Thank you.
Thank you, Chair, and we appreciate the opportunity to present. I'm just going to say a little bit by way of introduction, and then I'll pass over to Martin. As ministers have acknowledged in the Assembly, the historic discrimination of women and girls and their children in mother and baby institutions, Magdalen laundries and workhouses should be a source of shame for us all. The Truth Recovery Programme aims to provide truth acknowledgement and accountability to those affected by these institutions and by their historical pathways and practices. And this has been an important ministerial, executive and departmental priority, and I've no doubt will remain so. It's important, I think, as we start, that we acknowledge too the many years of campaigning by victims and survivors to get to this point. And while, of course, there is much work still to be done, there is now a process that has been agreed by the Executive to deliver these aims. We, for our part, as in my team, look forward to working with and to assisting the committee in their important role on this. Conscious of that role now and conscious of that role when legislation comes forward, and there will be very intense scrutiny. So I'll hand over to Martin, first of all, just to outline the progress that has been made to date, and secondly, to say something briefly about the plans for the public inquiry and the redress public consultation, which we hope will launch in the coming weeks, subject to the executive agreement.
Okay, go ahead.
Thank you, Gareth, and thanks to the committee for inviting us today. As Gareth outlined, I'll provide a short overview of the progress against the 5 recommendations agreed in November 21 and contained within the design panel report. Recommendation 1 centres on the principles. This includes having a victim survivor centred approach, and in practice this has been demonstrated through 2 key elements. Firstly, a monthly victim survivor consultation forum, which has met on 30 occasions and has been chaired by our independent chair, Avla Kilmurray, and you'll have the opportunity to hear from Avla and some members today. At times these have been challenging meetings, but they've been important and provided an opportunity to inform, consult and challenge, and have helped us get to this point. There's ongoing work with 4 members on how the next phase looks, including rules around advocacy. We thank all those who attend and have participated for their important contributions. Secondly, over 300 people have accessed dedicated and comprehensive support services. This includes general and individual needs packages, including psychological, social, information retrieval and oral testimony support, and these have been tailored to the needs. Recommendation 2 centres on the responsibility of the Executive Office. This has included the establishment of a programme and close working with colleagues in the Department of Health around access to records, justice around legal support, and communities in the preservation of documents via the Public Records Office. Recommendation 3 centres on the investigation, seeking to answer 3 core questions. What happened, why did it happen, and who was responsible? And this is for the period between 1922 and 1995. This is a 2-stage process, the first stage being a non-statutory 10-person independent panel appointed in April 23 for a period of 24 months, and you'll have the opportunity to hear from them in the next session, including on the findings of their interim report and their focus for the next 12 months. The second stage is statutory public inquiry, which will have the additional powers to compel evidence and holding of public hearings. Public consultation in relation to the inquiry will outline powers equivalent to the 2005 Inquiries Act and will seek views in relation to this. Recommendation 4 centres on information, and this includes the preservation and access to information. So the passing of the Preservation of Documents Act in 2022 was important to preserve statutory and non-statutory records in relation to this. TO has commissioned PRONE to survey, preserve and digitise over 4,500 items from private collections held by institutions. Deposit agreements have been put in place for 3,000 items to date, based on the close working relationship by PRONE and the independent panel with the institutions. Importantly, these records examined there will also be an examination of records held by and for public bodies in PRONE and elsewhere. Individuals being able to access information about themselves has and remains a key issue, with many adoptees and birth mothers being unable to access the information they're entitled to. This has caused understandable frustration and distress. To help address this, adoption practice guidance for social workers and adoption agencies responsible for the release of historic records was issued in November 23, developed by the Department of Health, and in conjunction with a small working group of victim survivors who co-wrote helpful and clear guidance. There's a programme of training and monitoring in place over the next 12 months, and we're hopeful for positive developments in relation to this. Recommendation 5 centres on redress and righting the wrongs of the past. This includes financial and non-financial redress. The public consultation will seek views on this, and we appreciate this is one of the most difficult and emotive parts of the process, with strong views held. The policy proposals reflect the recommended 2-stage process with a standardised payment before a formal investigation concludes, and this is likely to be based on admission to an institution, and the individually assessed, which would follow the public inquiry and be based on an individual's experience, likely to include factors like duration, severity and impact. The redress consultation will also seek views on proposals to establish an independent body to administer the scheme, gather views on the policy proposals with a focus on the standardised payment, including the eligibility, posthumous claims, which have been key issues in the pre-consultation engagement and have important equality, privacy and human rights considerations. Ministers plan to meet directly with victim survivors ahead of the consultation. It's planned to be a 12-week consultation in total, and we'll have a number of face-to-face and online events, with these being advertised to encourage a wide participation. This is an important call to action and enable people to make an informed choice on how they can engage with the programme based on their preferences and the support available. Once the public consultation closes, work will be taken forward to rework the draft bill before seeking ministerial and executive agreement ahead of introduction into the Assembly this year. To conclude, there is a clear moral need to comprehensively deal with these issues in a clear and sympathetic way. Despite the many challenges and acknowledging that there's much more work to do, it's important to note the meaningful achievements driven in large part by our victim survivors, including the 300 people who are accessing the co-design support services, the consultation forum which has met on 30 occasions, the independent panel being appointed and the interim report, the passing of the Preservation of Documents Act and the identification of the 4,000 archival items and the deposit agreements for the same, the development of the practice guidance which developed co-designed by victim survivors, and the preparatory works for the upcoming public inquiry and redress consultation. We're committed to helping to provide truth, acknowledgement and accountability to those affected, and we thank you for the opportunity for some opening remarks, and we're happy to take any questions.
Okay, thank you very much, panel. I really appreciate it. I'm just going to start way back in 2016 when I first came to the Executive Office and met with, I think, maybe one of you anyway. And at that time, the Birth Mothers and Their Children for Justice were calling for a public inquiry. So then we had the research commissioned from Queen's and UU in 2018, and this was to set up the business case for a public inquiry. Then we had the Truth Recovery Design Panel set up in 2021, October, recommended April 2023, the Truth Recovery Independent Panel, and then now in May 2024, we've got the consultation on a public inquiry. So I appreciate it's 12 weeks, then we'll have the appointment. That's going to be 10 years. Why did you not listen to the Birth Mothers and the Children for Justice 10 years ago? It was clear that there needs to be a public inquiry into what happened.
We're following here a process which has been followed across a range of areas, where we do research, establish the need for a public inquiry reports, there's a redress scheme, and the issues that a public inquiry has identified can be addressed. And we have sought throughout this to listen to victims and survivors. But there is an evidence base that needed to be gathered through research and through the Truth Recovery Design Panel. There was a co-design process through that panel that needed to be worked through. Now, we all would have liked, in retrospect, to have been able to got through these stages quicker, but it's been important that we gathered the evidence base, that we did the co-design. And you see in other situations where when those stages have been missed out, there have been issues further down the line.
10 years. I'll move on. So the redress scheme, was there talk about the potential for a cut-off date for posthumous deaths? Is that going to be consulted upon? And I'll come back on it just a wee second in terms of the consultation. The other issue is in the Truth Recovery Independent Panel, they talked about publicly funded legal advice to get the institutions to provide records. Can there not be provisions within the bill that would compel, I know you've talked there about preservation, but compelling them to hand them over? Because why should public money, and I don't mean that flippantly, but be spent whenever they should be compelled to hand over these records? And can we not consult on that in this bill?
Maybe if I take the second
Sure,
issue
okay.
first. So I suppose what the independent panel recommendations outline is about the legal support which is available to people, particularly in terms of accessing personal records, individual records, say specific to their adoption or their care, and it is specifically in relation to the records which are held by public bodies and adoption agencies, so the 5 trusts and then the 3 non-statutory adoption agencies. So it's about trying to provide additional support to those people to access information about themselves. Now, I think...
Before you go on, but that's even worse. If these are publicly held records, should they not be handing them over? Now, Connie and I have written to all 5 trusts to ask them about the training and the introduction of the new guidance in terms of handing records over, and the feedback we've been getting is quite positive. So why would there need to be legal advice and support to access public records?
So, I suppose it's the specific issue is around adoption records and basically about adoption regulations, about what information someone is entitled to under the adoption legislation, and it's basically around GDPR. Right. So it's around GDPR, and it's basically about what individuals are entitled to access about themselves. So the reason why legal support specifically is has been requested and recommended is that really around access to records is about another form of redress or another potential form of redress. The adoption practice guidance aims to provide meaningful and pragmatic support for social workers who have an obligation to basically everybody who is in an adoption file, including people's right to privacy. And so there's data in adoption files that will have mixed data, and then it's just making sure that they've got the right and appropriate legal basis to share information about the individual. So
what it is important to acknowledge alongside that's about individuals getting access to their records. The public inquiry will have statutory powers to call for information and to receive it. The redress service will have statutory powers to insist on receiving information. So in terms of what you were saying, Chair, about there being powers in the legislation to insist that this is provided, certainly in terms of the inquiry, in terms of redress, those powers will be there.
Did you cover my first point?
No, I didn't. So just in terms of posthumous, so
yes.
The posthumous claims, I suppose the design panel report didn't specify whether there should be posthumous claims or not. So I suppose there was a decision for the department about what we should do around posthumous claims, and I suppose we tried to look at a number of different schemes to try and see what precedence was. So some redress schemes don't permit posthumous claims. We felt that it was important that posthumous claims would be included, and then I suppose there's 3 or 4 key questions that we would like to ask as part of the consultation, which would include basically, do you agree with that? So do you think posthumous claims should be included as part of the redress scheme? The second question is, if you do agree that posthumous should be included, at what part of the scheme? Because we've got 2 stages. We've got a standardised payment scheme, and then we've also got the individually assessed, so trying to get views from people about whether it should be eligible on one or both or neither. And then the third is on what basis who should be entitled to submit a posthumous claim on behalf of a loved one and a deceased relative. So there's a number of different models that have been used in others, including sort of an executor of an estate. There's also a model which has been used in HA, which is around residual beneficiaries. So that's also tied to the estate and intestacy law as well. Or the third element, which we're hoping to consult on, which is around next of kin. So allowing people, spouses, partners and surviving children to make a claim on behalf of a loved one. And then the fourth question is the date.
Yes, so there was the 2010, I think that was the issue.
Yeah, we've the proposal that we did some pre-consultation engagement before Christmas, and the precedent looking at other schemes was November 2021. I think there's other, it's trying to get views from people on that date, and if not that date, then what other options are available. So. Okay,
so last one for me for now. So the redress scheme, we found with the HIA, Sir Anthony Hart, a year before the inquiry report said there was going to be a redress scheme, and then it took, so it was 2017, say before that, and it took until March 2020 before the scheme was open for applications. So how do we know that there won't be the same level of delays, and also with the redress board going to cease taking applications? Is there learning from that redress board, but also is there potential for that board maybe just to morph into this?
Yeah, I think that's the intention, is to try and use as much of the infrastructure and much of the, so there's practical things like IT, facilities, staff, and, I suppose the key thing is trying to use as much of that experience and some of the practical side of that as well. That's should make the process on the other side of the legislation quicker and more efficient, and you've got the opportunity. And I think there's other things from the experience of other redress schemes that we want to try and build in, and that includes about supporting people through that application process. And I suppose some of the critique of other redress schemes is that they can feel very legalistic or legal processes, and we want these to be supported processes. And some of the models around caseworkers who are supporting people to prepare an application, and also have that opportunity to have legal support there for people to make informed choices around redress as well. So those are some of the practical things. But there's also then some things that will be specific to this programme, and will add different things that we have to consider as well. But I think the intention is to use as much of the infrastructure as we can, and also try and learn lessons from other schemes and some of the challenges that they've faced as well. Is that fair?
And there is a fair amount that you can have, that we can be working on in the meantime, yes, and have ready to go once legislation is through. And in fact, some of those conversations about operationalising all of this are already happening.
Move on. If some more questions, we'll move on. Connie, please, Deputy Chair.
Thank you. Thanks for coming in tonight. My first question really is around if you're aware, and if so, what work you're doing on unmarked graves. There's been calls recently from family members, victims, survivors and archaeologists around babies from mother and baby homes which were not buried properly and were put in unmarked graves. It's been incredibly distressing for them to now learn that some of those graves are now, as they understand, being disturbed. What work does your department do to ensure that all records and graves are preserved from mother and baby homes?
Yeah, I think first of all to say and just acknowledge that, I mean, I suppose this is one of the most distressing elements of not only in terms of the design panel's work, and I think the work today is around unmarked graves and about the burials of infants, and that could be babies or babies from mother and baby homes or from baby homes themselves. I think the inquiry is focused on the investigative side of that, and I think there's meaningful powers there around compelling evidence, particularly looking at the difference between burial and death records, and also looking at infant mortality rates. I think the separate question around protection of those, I understand there's some legislation which currently sits with the Department for Communities around burials and the protection of graveyard sites, and there's specific orders that and powers there. I think there's discussions in relation to that around what powers are available at the minute, but I think in terms of the public inquiry, it's definitely focused on that sort of investigative side and trying to establish the evidence base around not only sort of infant mortality rates, but then specifically around that difference between burial and death records, which is a key part of that sort of evidence base.
Yeah, go ahead.
Have you had any conversations with the Department for Communities around this? Because it's happening, the campaigners have informed me this is happening now. They're really distressed about this, and there needs to be some urgent action to make sure that the unmarked graves aren't disturbed. Have you had any conversation with the Department of Communities about getting something urgently in place to stop that from happening? We've spoken to the Department for Communities, and we're happy to write back just once we have a bit more information. Those discussions are ongoing, but happy to come back to the committee on that. So. Thank you.
Okay, thank you. Carol, please.
So I don't understand the difference between records that are in the public records building that people can't get access to. I mean, you've got data protection legislation, you've got GDPR, you've got the Public Records Act of 1922, you've got FOI, and you've got non-FOI and undertaken. So why is there a need for an additional layer for people trying to get access to their records?
I think it's specific to, so I think there's evidential records which will be important for both the independent panel and for the public inquiry. So those are 4,500 items, and they're a mixture of let's say registers. They're a mixture of individual files about an individual. Some of those, if an individual chooses, can go and request that information from an adoption agency. So that is an individual requesting information about themselves. And when an individual presents and puts in a request for that, then a social worker has to look at that file, gather the information in relation to that and then disclose what they feel based on the legislation they can provide. So there's
What legislation is it they're benchmarking this against?
it's the 87 adoption order legislation is the
But we amended that recently.
it was amended, but there's still the practice guidance is about how that actually works in practice. So it's about these are still balancing tests for social workers. They have to determine what.
I'm sorry, that's not good enough. It's not good enough. So we're waiting on the civil service catching up with legislation that we've done recently. And even under Article 8, people have a right, which is engaged. It's an engaged law to have access to records for private and family life. And you're telling me that a 1987 piece of legislation still hasn't been caught up with. When do we do that before the...
Oh, yeah, that was probably about 21, 22, the
Yeah.
Adoption and Children's Act, yeah.
Yeah, so it hasn't caught up with that, and people who are trying to get access to what happened to them have to wait on the civil service catching up, basically.
Well, I think the adoption practice guidance is there to provide support to social workers in order to the principles are about maximum disclosure. So there's a balancing right in Article 8 around basically privacy as well. So it's about sort of balancing the rights of, let's say, a birth mother with the balancing the rights of an adopted person. So it isn't that we're trying to deny an individual access to information about themselves. It's just about trying to provide information that's clear and standardised that a social worker can look at an adoption file and decide based on the information and the guidance that's there what's the maximum disclosure that they can provide. So
does the 1987 order supersede freedom of information, non-disclosure, 1922 Act and GDPR and Data Protection Act?
Well, I suppose the Data Protection Act actually supersedes some of what was in the 87,
Yes.
and it's in Northern Ireland there was an exemption which was applied in the rest of the UK which wasn't applied
Right.
here. So that's an issue which is to resolve that exemption on a statutory basis in Whitehall, but the practice guidance is written and should be deployed as if the exemption was in place. So it is trying to give effect to the exemption as if it was in place, and I think the key thing in terms of the adoption practice guidance, it's actually a very clear piece of guidance. It gives a very clear view in terms of what people can disclose and what they should redact, and the things that they should redact are very limited. So the question is about the application of that guidance. So it is about trying to support social workers, and there's been a number of workshops that have been completed with so Deirdre Mahan, who was one of the lead authors of this, has been commissioned by the Department of Health to provide support to social workers who deal with adoption in the 5 trusts plus the 3 non-statutory bodies as well, so there's a consistent and a clear way.
See, the 3 non-statutory bodies, are they religious orders?
So some of them are affiliated, so Family Care, Bernardo's, and there's another one who
I know,
how about
and I can't mind their name either.
Yeah.
So what's to stop them destroying their records?
Well, the Preservation of Documents Act, which was passed in 2002, makes it, or 2022, makes it, there's an obligation for them to preserve the records that they hold, and that applies to not only sort of non-statutory bodies, it applies to statutory bodies as well. So there is a piece of statute which means that those records have to be preserved. So that's what's in place.
So I think Paula made at the start about having to wait 10 years. And it just seems when people are getting close, the system adds a lot of bureaucracy and process, and the outcome seems further away. And I just think it's really unfair.
No, we feel that frustration as well. Like we're hearing, there's very considerable distress, and look, hopefully you can hear some of that in your evidence sessions as well. And I think the key thing is about trying to resolve this. This is about what people should be entitled to, and it's about trying to provide access to that. So.
Future.
Okay, I'm just going to I think I took you down the wrong angle or a different route here. But again, in the independent panel's report, it says discussions are ongoing with those institutions or organisations that have not yet agreed to facilitate digitisation or unfettered panel access to records. Again, is that going to be consulted upon, or are you suggesting that through the public inquiry that information will come forward? Because quite frankly, I've lost my patience with these institutions, whether it's the children's homes or whether it's these mother and baby institutions. I've lost my patience with them holding us to ransom in terms of accessing money or records. What's happening there?
I suppose the first thing to say, the 4,500 items that have been identified, 3,000, with 3,000 records across a number of institutions who have deposit agreements in place. The other two, and maybe Sean and Leanne from the independent panel can provide a more detailed update on this, but there's ongoing discussions with those institutions which are remaining. Yes. And part of that is around the just some of the safeguards and legal basis around that, but the option will be there in the public inquiry to compel those. That is a power that the public inquiry will have.
Okay, Brian, please, thanks.
Okay, thank you, Chair. Thank you for the information so far. Certainly, the more I read about this, I have to agree with Gareth's comments at the start that this is just a shocking indictment, in society, and the scale of this, and whoever's interest was being served by the running of these institutions and how people are treated, it certainly wasn't the women themselves.
No, 100%.
And it wasn't their babies, for those who were pregnant or had who were mothers, and it is shocking. And just on page 53 of our briefing paper, if I can read this. Among Magdalen Laundry residents, there would have been women referred by the criminal justice system, girls transferring from industrial schools, women fleeing domestic violence, and those with substance and mental health issues. And the fact that it was considered appropriate, setting for people, such a wide range of circumstances, and how they were mistreated, so it is obviously further shocking to us how far behind these institutions seem to be in the process. We have heard from other historical institutional abuse centres, and this process seems to be much in the slow lane, much further behind. So I don't understand why it has been set up and treated separately, whether it's just the scale of things. It says in our briefing paper 10,500 women estimated entered mother and baby institutions, 3,500 women in Magdalen laundries, these are 1922 to 1990, and 20 workhouses. So first of all, why have they been treated separately? Why are they so far behind? There's no redress scheme currently. We're only at the start of a truth recovery scheme. The institutions, the pursuit of them for financial compensation seems to be at a much earlier stage. Is this being expedited? How can it catch up? Because the women affected must feel once again that their interests have been neglected. What has been done to expedite this process?
Thanks.
The women who are affected by this have always been part of the picture, and have always been part of the plan. And I think what you've highlighted, Brian, is that there is a state side to this, and there are things that are very wrong in how the state came to the treatment of these women as well as the institutions. So they've always been part of the picture. A decision was made that there would be a phased approach, that the work on HIA was reasonably far advanced, and rather than hold that back and add other groups in, that would proceed, and then that the group of people we're talking about today, and indeed the wider issue of historical clerical child abuse, would be dealt with separately by the interdepartmental working group that was set up. So I recognise that this has been a phased approach, recognise all that you say about having taken time, but I would just want, on behalf of the department, to reassure people that this has always been part of the plan, and people, that this isn't about first class, second class. This is about recognising our responsibilities as a department.
Well, can I ask further on that? Has any is any process in place for women to register? And because I presume there'll be criteria when a redress scheme comes into place.
Yeah.
So is there an opportunity for women to register? Whether or not they will be fully assessed at this stage. So at least we're capturing people and they know that they are recognised.
And that we will keep people up to date.
So Brian, there is registration lists or mailing lists that people can join to find information, updates on the programme, and the support services are a sort of key part of that. There's also other options that people can join at the minute, which is our consultation forum, which is part of that in terms of opening up for applications for redress, if that's what you're there isn't that in place at this point, but there are opportunities in terms of public calls, particularly as part of the public consultation, will be about trying to ensure that we've got information and people can register for the programme and people can access different parts of the programme. So the independent panel, key part of their work over the next 12 months will be collecting oral testimony. So that is trying to provide supported oral testimony so that people can feel comfortable. The feedback from the people who have provided oral testimony to the panel to date has been excellent and has been very supported, and have they've, I think, great care and expertise in that process, and I think that's the main sort of initial call to action. But the public consultation was a key part of ensuring that people know about the programme and also know what bits of the programme they can access now and what bits will come later. So.
I don't know if you'll let me just briefly, in terms of the institutions themselves, at what stage are the negotiations with them for the compensation they need to be providing?
So I think the engagement with the institutions to date has been twofold, really, in relation to records, which has been led by Prony and the independent panel, and the second is around the public consultation plan. So we've offered briefings to institutions in relation to that. I suppose a key aspect of this is about formal investigation, so we have to enable the formal investigation to work its way through and answer those questions around what happened, why did it happen, and who was responsible. So I think that's important that we have to go through a due process around that. So contributions haven't been as part of those discussions, other than if there was responsibility deemed, that there would be then a process that similar to HIA. So it is about trying to establish the facts in relation to this first.
Okay, so we actually haven't reached the stage of their obligations, financial obligations, being recognised.
Well, I suppose we have to have the investigation in order to. There's, I suppose, elements of a sort of human rights investigation, which is about procedural fairness as well. Now,
what we can say, I think, is that there would be a full intention on the part of the department, if it is demonstrated that there is fault and blame systemically, that we would pursue for contributions in the same way as we have done for HIA. But as Martin says, we need to let the due process happen before we get to that point.
Okay, well, it is unfortunately, as I feared, that very much at an early stage compared to others. Okay.
Thank you. Sinead, please.
Well, thank you, Chair. I'm going to be a wee bit pedantic about this, but in the papers, in page 52, you're kind of laying out the key facts and background figures on mother and baby institutions. And you've indicated that there's 10,500 women entered. Obviously, then correlation or assumption that it's 10,500 children subsequently born to these women, but probably not, because a lot of them died at birth or before birth. But anyway, but this represents about a quarter of all illegitimate births during that period. I don't like that terminology. I think it's hurtful for the mums and the babies.
Yeah.
There's no baby is illegitimate. And so this is research from Queen's University, I understand that, but I just think we really need to be careful of the words we use when we're preparing papers.
Yeah, of course, and like that. So that was that. Just first of all, to acknowledge that and to apologise. We've been very careful about in our documentation. That was there was a terminology section at the start of that research which outlined some of the why that was included in that terminology, and it's just to acknowledge that isn't and shouldn't have been, and that shouldn't be part of the briefing pack. So apologise for that. So.
It's okay. So on page 42 of the papers, you refer to the ongoing engagement with the institutions, and is this ongoing engagement ever going to end? And what's the deadline for that work? And are you being assertive enough and ambitious enough as a department in order to get what you need from the institutions in terms of redress and contributions in that? So can we speak just about how ambitious are you to get those completion of those talks, etc.?
Gareth, do you maybe want to talk about the HIA process, or
you go ahead.
So I suppose in terms of the truth recovery, the engagement today at Sinead has primarily been in relation to records and the plans for a public consultation. The process that HIA has followed around that sort of negotiation, mediation, arbitration process is, if in terms of responsibilities deemed in relation to this, and I suppose the question is also about how much responsibility, then that is the position then in order to have a basis for negotiations to start in relation to that. So I think we're at a slightly earlier stage in the truth recovery process than we would be at HIA, which is at that advanced stage where there's been payments which have been received, and I don't know, Gareth, anything you want to say over and above in terms of HIA?
No, I mean the engagement, as you said, down the line, some of it will be contributions. At the moment, it's focused on records. I think the fact that the Public Records Office now has commitments for over 4,000 records to be transferred across is significant. I think that will make the task of the public inquiry easier because they can be indexed and so on. But I mean, we're committed to working with the remaining institutions. There's different ways in which records can be made available, but in making sure that there's as much transparency as possible.
Okay, Gareth. The paper also refers to the consultation forum and about relationships within the consultation forum. From my engagement, some victims and survivors have found that forum very, very difficult.
Yes.
And feel that they need a voice. So they've talked about, an advocate for them. What's your thoughts in getting support or a commissioner to advocate for them at this stage of the work of the consultation forum? And also, you've had one in-person hybrid meeting, which I think they found very, very useful. Are you planning more?
So I'll maybe invite Pauline maybe to say a few words as Secretary of the Consultation Forum, but I suppose to give my view, Sinead, is that I think the forum, they have been difficult meetings and these are difficult issues, and it's just to acknowledge that and to thank the people who attend. This is really, for us, is about, there's lots of moral and legal issues that have to be worked through here, and those meetings have been very helpful in terms of not only shaping what the actual policy is, but about how the policy is delivered as well. but there's an intensely personal element to this, and there's lots of things. For example, we were talking about access to records, very considerable frustration around access to records, and some of those things haven't been resolved satisfactorily, and it's trying to get views and trying to work together in order to resolve those things. In terms of an advocate, I think there's an ongoing piece of work which Avla and others could perhaps talk about basically what support and what things that they think would be valuable in order to aid victims and survivors to engage with this process. This is a complicated process as well. You know, there is two forms of redress in terms of two schemes. There's two forms of investigation, and having an advocate, there's definite benefits around that potential advocacy role. What that looks like, whether that's an individual or more than one individual, or whether that's advocacy support through a different method, so through VSS, we're open to that as a department. So I think it's just trying to work with our forum to establish, well, what are the suitable routes to do that. So Pauline, maybe do you want your reflections and maybe about face-to-face engagement?
Okay. Well, yes, we only have had the one hybrid meeting, and whilst it was difficult, it was very useful. Part of the reason for having them online is that we have people who would dial in from Canada and America and the like. So 4 o'clock. It's not to say we've had some smaller engagement sessions face to face, you know, for particular themes of the report that are difficult maybe to have that conversation over Zoom. And they were very, very helpful, not only for us, but I think from the victims and survivors' perspective as well. Avila will talk about her and the work that her and Danny Taggart are doing in terms of smaller engagement to try and make the forums a safer space, because, you know, at times it isn't. And Sinead, you talked about some language there, you know. As officials, you know, there are things that are very transactional for us, and we need to do it. But I think we have worked very, very hard to recognise the emotive and emotional and the distress that sometimes our processes can have. So we do intend, we would hope, to run more face-to-face sessions. But by the same token, we don't want to leave anyone behind. So I think it would be a mix of still using Zoom as well, just to be inclusive.
And certainly if there are any ways, and I mean, we're not, there have been a lot of benefits come from the structures that we've had, but we're not wedded to them. And if there is a better way, better ways of doing engagement for the future, then very open to those.
Okay. Harry, please.
Thank you very much, Chair. Martin, you said at the start you have monthly meetings with victims, is that right?
That's right.
And how many would attend those sort of on average?
Yeah, there's normally between sort of 15 and 30, Harry, who would be attending. So there's probably a cohort that would be attending every single month, and then there's others who will dip in and dip out. And we try and, I mean, these are open forums. We send them out to, there's I think about 80 or 90 on our mailing list that basically get agendas, papers. So there's an agenda goes out roughly a week in advance. Papers, where possible, we try and send out papers. That wasn't always the case, and we've tried to send out papers in advance of that based on preferences. And then there's minutes of every meeting, which is recorded and issued in advance of the next meeting. So we've tried to have it quite structured, and it's not perfect, but we've tried to leave it open, and they're monthly from 4 to 6 normally on a Thursday, sort of second or third Thursday in the month. So.
And Chair, just to be follow. And generally, would it be the same person that they get to deal with? Do you know what I mean?
Yeah,
to make it
so
easier, you know.
We've tried. So I suppose Pauline and Michaela and myself would be attending primarily from TO perspective. It's chaired by Avla, who's been a great help in terms of supporting us through this process. And I suppose one of the things that I think is unfortunately part of this process is that there, as Pauline said, there's elements of this we're policy makers, and some of the language, some of the things that the processes we have to go through can feel a bit arbitrary at times, but I think there's been sort of through those forum meetings, and we've had about 30 of them to date, I think there's been good engagement, and a lot of the achievements which is outlined here are down to that forum, and we should acknowledge that, and a lot of the progress and a lot of the drive that has been delivered has been as a result of that forum, and they should be commended for that. So.
No, appreciate it. Thank you. Thank you.
Okay,
Thanks,
thank you,
Chair.
Harry. Emma, would you like to ask a question?
Thanks, Chair. Can you hear me okay?
Yes, go ahead, please. Thanks.
No, I suppose I don't really have a question as such. I mean, the details laid out in the written presentation are fairly sober, and just like I think Sinead touched upon it there, like the figures, the number of women who were victim to this, and obviously their children. And I would sort of just echo all of the frustrations from yourself, Carol, and Sinead specifically around the length of time that this has taken, the language that's been used, and I mean, I suppose just the risk of re-traumatizing people who've been already through the most horrendous of an experience. So just to associate myself with those comments, and I appreciate the panel taking the time to come and engage with us, and the work that they are doing as late as it might be.
And it's perhaps, Chair, just worth emphasising, because I'm aware that survivors may be watching this, there is a very comprehensive suite of support services, trauma-informed support services that's available. Into the hundreds of survivors have already accessed those, and through the Victims and Survivors Service, we will pay whatever is needed to deliver, and we'll support people in whatever ways we can. So just to note that those are, whatever might be in the future about redress, those are currently available.
Okay, thank you. Thank you, Emma. Padraig, do you have a question? Okay, all right. Well, listen, that's all for today. Oh yes, sorry. Go ahead, Padraig. Go ahead.
Sorry, Chair, I'm not sure what's going on with my camera's not turning on for me there. But no, look, I think everything has been covered really. You know, from my perspective, it was just everything that's already been said. Just the only, I suppose, thing to add, you know, we're keen to hear from the Truth Recovery panel as well, and more on that. But I have quite a few questions in that next part, so I'll put my name down to speak early on that.
Okay, thank you, Padraig. I'll bring you in early. Okay, well, panel, thank you so much, and obviously we're very keen to see this consultation, and we look forward to an update shortly. Thank you. Okay. Okay, thank you. Panels then, just moving on then, our next panel briefing is from the Truth Recovery Independent Panel. So page 55, you'll find the clerk's brief. Page 57, a cover letter from the Truth Recovery Independent Panel. Page 58, a written briefing from the Truth Recovery Independent Panel. And on page 79, the Truth Recovery Independent Panel's interim report from May 2024. Okay, so I'm going to bring the...
Is there figures on the number of women that left here to go over to the likes of Scotland in that? No?
Not sure. Sean, who'll be here, he did the original research for Queen's, so he should be able to maybe pick that up. Okay, welcome.
How are you?
Okay, so members, we're welcoming to the meeting Professor Leanne McCormick, who's co-chair of the Truth Recovery Independent Panel, Professor Sean O'Connell, co-chair of the panel, and Roisin McGlone, who's a member of the Truth Recovery Independent Panel. So you're very welcome. Good to see you here at committee, and I'm just wondering, do you have some opening remarks you'd like to lead on?
Do, if that's okay. Thank you.
Thank you, please.
Chair.
Go ahead.
And good afternoon, members of the committee, and thank you for the opportunity to speak to the committee today. I'm Leanne McCormick, one of the co-chairs of the Truth Recovery Independent panel, and just very briefly, I know you've got our interim report in the written briefing, so just very briefly about the establishment of the panel. In October 2021, the Truth Recovery Design Panel published its report, and the Northern Ireland Executive agreed to implement the recommendations in the design panel in full. Recommendation 3 of the Truth Recovery Design Panel's report related to the establishment of an integrated truth investigation comprising an expert independent panel and statutory public inquiry, and the panel was appointed in April 2023 following a public appointments competition. There are 10 members of the panel. Uniquely in the context of an independent panel, there are 3 victims and survivors on the panel, as well as members on sociology of discrimination and gender-based violence, trauma-informed practice, human rights and domestic law, archives, genealogy and social and oral history. We have a number of strands to our work, as you know, and just briefly to reference some of the work on archives and records that I work closely on, closely with the Public Record Office of Northern Ireland, PRONI, in identifying, locating records, working with institutions and organisations, and the process of then conserving, preserving and digitising records. This last process is particularly important, both in making sure there's a high quality copy of all records, but also so that the independent panel can work efficiently and effectively on these records as well, and that they are available then for the public inquiry, and most importantly as well, access for victims and survivors. As mentioned, as you've heard before, there are a large number of these have been collected and are digitised in the process. Confidentiality is very important as part of this as well, and we have data sharing agreements in place. But also as part of this, it's very important that victims and survivors do have access to their own records, and part of our role is in terms of advocacy. And I'm just going to hand over to Roisin now to both introduce herself and speak a little bit about that aspect of the work.
Okay, hello. Well, my name is Roisin McGlone. Thanks very much for having us here today. I'm here, I'm a member of the independent panel. I'm a victim survivor appointee. I'm a birth mother who, as a young girl, actually a child, was in the mother and baby home, and my son was adopted. Some of you may know my face from the voluntary and community sector, where I've worked all of my life. I've worked in conflict resolution in issues like parades and policing and community development. So I suppose in terms of the access to records, I know that there can actually be some confusion sometimes here. When people don't really maybe get the differences between sort of the work that Leanne's doing, for example, and the work that me and my colleagues are doing in the Access to Records. We've actually got quite a long name. We're called the Access to Records, the Advocacy, Legal Service and Genealogy Group. So get that one, get your mouth around that one. And I suppose one of the things that became very, very apparent from the truth recovery process, but also from listening to victims and survivors, was the fact that there was this maze out there, and people have referred to it here at your committee, and I know that you're aware of it. There's this maze where people don't know where to start. If you could imagine, people are on a continuum. You know, there are some people maybe, for example, that have been involved in this for maybe 4, 5, 10 years, as you've mentioned earlier, that maybe have found their way through the maze, and then you've people that are coming to this for the first time and they've absolutely no idea, where do I get a birth certificate? If I had a child, where do you get the birth certificate? Where would I look for records about my care when I was in the mother and baby home? Where would I look for medical records as to what happened to me? Where would I look for a court record? You know, where do I start this journey of mine? Because many of you will either, I don't know if any of you are adopted or have adopted children, you may do, but if you don't, and many of you have children, it's a very natural thing that children know from the granny, the stories from the granny's knee about what happened to them when they were born and whatever. People that had children that were adopted and taken from them, and adoptees don't have those stories, and so they want to put those stories together. And listening to people, it's one of the very saddest things that we still have this situation where it's not easy in our society for people to find out their story and to find out what happened to them, because there isn't the people to tell them. If they haven't found family members, there aren't people to tell them. So on the Access to Records, and I won't do the rest of it, group, what we've been looking for is to develop a guide, and that's a guide for individuals. So that is, if you can come to either the website or eventually to a hard copy guide. And what it'll be is, if you're looking for a birth certificate, here's who you go to. Here's what it'll cost, although some of the costs can be met from VSS. If you're looking for an adoption record, for example, it may be that you went through the mother and baby home, so it may be that some of the adoption agencies have those. And I won't go into an awful lot more about that, but that's the working group that I'm on. So that's just a sort of a short introduction to say that's the work. Now that work is finished. We are just doing accuracy on it and making sure that solicitors have a look at it and that it's data protection. There is GDPR, all of that advice in there. There's legal advice in there, and then there's also the institutions and the different trusts. Okay.
So I'm Sean O'Connell. I'm the other co-chair of the independent panel, and my main responsibility, apart from co-chairing, is to work on the testimony and analysis working group. So testimony is at the heart of what we do and what we will be doing, and it's going to be at the heart of our report, and we write it at the end of the day. I think we've learned a lot from previous reports in other parts of this island that were less successful, I think, than we hope to be around how testimony is used and the primacy of testimony as a form of evidence, the lived experience of the individuals who come forward and tell us their truths. So it'll be absolutely at the heart of what we do. It'll be trauma informed. We've all been through a very careful training process with people who previously worked on testimonies of this type, collecting testimonies of this type. That includes myself and Livy D, who worked on a project with us earlier that was published in the 2021 report, but also with Beverly Clark, who's also on the panel, who's a trauma-informed specialist. And we've worked with the testimony facilitators that we've recruited to ensure that we do things absolutely as well as we can and we don't cause any harm in collecting the testimonies. Working also with the Victim and Survivor Service and Adopt NI and WAVE to ensure that there's support in place for all those individuals who do come forward to us. So we've been very careful about how we roll the testimony process out. We've been slow and cautious to begin with. One, because we didn't want to overwhelm VSS and WAVE and Adopt NI with lots of new individuals coming forward looking for their services and supports. But two, because we also wanted to get things right. We wanted to assess carefully and cautiously as we move forward ourselves. And we've been in contact with 35 individuals so far about testimony collection. We've collected testimony, I think, now from a dozen individuals, and all the feedback that we've had so far has been very positive. So we're very happy about that, but we won't rest on our laurels. We'll keep assessing that as we move forward. So just today, the second invite has gone out for the second wave of individuals who will want to come forward and speak to us. And so those individuals, possibly up to 50 or 60, we'll take testimonies from them across the next 3 or 4 months, hopefully. And then in October, we'll be looking at a third phase, which will be allied to the comms strategy that we develop that's about finding new individuals out there, people who are not currently registered on our database, people who haven't come forward yet, perhaps even don't know that we exist at this moment in time and need to be made aware of that. So we have big plans about how we want to do that. In terms of who we want to speak to, it's obviously many people have assumptions about who we want to speak to, people who are associated with the institutions, people who are residents, if we want to use that term. Some people would not like that term, of those institutions, incarcerated in those institutions in other instances, but also their relatives, partners, people who worked in the institutions, people who are associated with the institutions, people who may be visited as part of their professional capacity, also those involved in pathways and practices associated with these institutions. So that might include private nursing homes, for example. It might include people who are involved in the cross-border transfer or movement of young children, or girls and women coming across the border into Magdalene laundries, for example. So there's a big range of people that we want to speak to. I suppose finally then, just to acknowledge again that this comes from it's a long process. As the chair mentioned earlier on, it's 10 years and longer in the preparation. So we'd like to particularly pay tribute to the victims and survivors who began that process. You know, particularly the people in the Birth Mothers for Justice group who began the process a long time ago, and the Truth Recovery Design Panel who developed this process, put the idea of the independent panel in place to create a space, a safe space, a non-adversarial space that didn't repeat some of the failings perhaps of the institutional abuse, historical institutional abuse inquiry, which we know from research did re-traumatise lots of individuals who came forward to give evidence. And finally then, just to remind you maybe of the recommendations that we made. I know that you've read, listening to you, I'm very impressed that you've all read the interim report, so thank you for paying us that compliment and that attention. So we'd just like to remind anyone who's perhaps watching who doesn't know what we've recommended. We recommended that ministers consider the early appointment of the chair of the public inquiry. You might want to ask us questions about why we consider that to be so important. We believe that in future uses of what is an innovative new process, that's an independent panel coming before public inquiry, there should be greater control for the independent panel members and co-chairs of the budget, so that independent panel and future independent panels can hit the ground running. We've also asked ministers to consider extending our work for 6 months, and we know that not all victims and survivors probably like that. It means a further delay potentially, but we think that we spent a lot of our first 6 months talking about things and trying to get money released, etc., and get things prepared rather than actually doing some of the work that we were asked to do. We've asked also for the removal of the means test for legal aid for access to records requests by victims and survivors, and I know you've already discussed that in the last session. And then finally, we asked ministers to continue to support efforts to secure access to relevant records in the government, in reports that have already taken place in the Republic of Ireland. So there will be lots of material down there that is relevant for us, that's in the Commission's archives, that's in the archives or that's collected by the McAleese report on Magdalene laundries. It would be ideal for us to have access to that when it relates to individuals from this part of the island. So thank you for listening to our opening remarks.
Thank you, panel. Thanks again for sending through the report. It was very useful to have sight of it. I suppose I just want to pick up on the point you made, Sean, there around the testimonies. And when the research you, Leanne, and others did way back, a lot of that was around testimony gathering. To what degree is there duplication? To what degree are those testimonies feeding into this? And the second part of the question, I think, Leanne, you had mentioned that they will then be available to the public inquiry, but we've known from other public inquiries in the past, then sometimes when there's a police investigation, then they can't be handed over. To what degree are conversations taking place with PSNI as well in terms of historic cases? Just a question, thanks.
Begin with the last point, and we have a referral process with the PSNI in place, so if anybody comes forward with testimony that includes allegations of non-recent abuse, then they are referred to PSNI under particular circumstances, if the individual is named, etc. So we've discussed that very carefully with the appropriate PSNI team. So and that is working. That process is working already, working well, I think. In terms of how the previous testimonies overlap with this testimony, so there was an option in the consent form in 2018-19 to have that testimony go forward for the use of any future researchers. At that point, we didn't know this concept of the independent panel.
Yes.
So most of those individuals at that point, the 60 people that gave testimony, most of them ticked the box for future use of the testimony. We've gone back to them and asked them, are you still content that happens? And pretty much everybody, maybe 2 have said no, everybody else has said yes. So those testimonies are, if you like, in the bank, although some of those individuals I think will want to give testimony again. They might want to give testimony in a different form. I should have said we're also offering the option of written testimony this time as well, so some people might prefer to write their testimony. So hopefully that answers.
Yeah, I suppose just a follow on from that is, again, it's the conversations that we had those years ago when you were doing your initial research around the difficulties in identifying, especially in terms of the laundries and the workhouses and stuff, in terms of how do you think that this process is different in terms of getting people to come forward and engage?
For a start, we'll have a bigger budget.
Okay.
You know, we will have quite a lot of money will be spent on a fairly extensive advertising campaign, which I think will make a lot more people aware of what's happening. Doesn't necessarily mean that what I think one of the issues around the Magdalene laundries in particular is that there's a smaller number of victims and survivors around those particular institutions. They are older than those associated with mother and baby institutions, so there's going to be a smaller number because of, unfortunately, many of them will have died off. And also there's a smaller number of survivors also who are now, they've moved from that institution into care home style institutions, and our kind of feedback is that they do not want to engage with the process, and I don't think nor would it necessarily be right for us to be knocking on the door of those institutions and seeking testimony from individuals who've made it clear, at least via intermediaries, if you like, that they are not, and we believe those intermediaries that they are not looking to give testimony. They, you know, in some cases they feel they're still carrying the stigma that was placed on them as young women, young girls. That is still very strong, I think, in those individuals. And again, we're reliant on second-hand, you know, not hearsay, but second-hand testimony, I suppose, to follow that through. In Macaleese, for example, they did take testimony from a large number of survivors of Magdalene laundries who was in institutions post the Magdalene laundries, and I'm very sceptical about how that came about. In that, you know, it seemed that large numbers of women were kind of bussed to Macaleese to give testimony, you know, by institutions. You know, I'm very, that's not ethical, you know, and I wouldn't want to try and repeat that process. I don't think anyone else on the panel would want to try and repeat that process.
Go ahead.
I also think, Paul, it's significant that we're an independent panel and, you know, we're not a public inquiry. And I know that speaking to some victims, survivors, they would be anxious about the adversarial nature of a public inquiry. And I think that, you know, we need to get the message out there that we're completely independent, but at the same time, there's an official position that we're in now as opposed to maybe the Queen's report, you know, where we're actually sanctioned in a sense. And I think that's important because Sean mentioned something there, you know, there isn't an organic group of women out there. These are individual women, many of whom have never told anybody about what has happened to them. And they're not necessarily going to come forward for us, but we need to try and touch as many of them as we can. But it's a bigger issue for me than just giving testimony. It's about us giving a very, very loud, clear message that it wasn't about bad girls. You know, This happened right across our society, and this was about our attitude to girls and young women and how we treated girls and young women, and in some senses continue to treat girls and young women. So for me, that's the importance of this. That's to me what's critical about this, and I was struck by some comments you read from your briefing paper, which were maybe a tiny minority. And I know you were talking about the laundries, but it maybe was a tiny minority. There was lots and lots of girls and young women who found themselves in circumstances that everybody assumed what the problem was. They had no idea about what the circumstances around conception were, but they all assumed that they knew and made all sorts of assumptions. And we've got to break that cycle. We've got to break that cycle so as that we can touch women out there that maybe up until now have felt they couldn't even tell their families, never mind an independent panel, you know, or an independent inquiry. So for me, that's the value of, we have a very short time, you know, this is a very short life in this whole process. We have to try and touch as many people out there as we can and give them the confidence. It's really important that we say now, this is all confidential. You know, no one is going to be identified. People are not going to be identified if they come for to give testimony. This is a confidential process for people who will be supported in the right way to go through this process.
Thank you. I'm going to move on. Connie, Deputy Chair. Thanks.
Yeah, thank you all for coming in today. And I think I wanted to kind of maybe follow up on what you said about making sure those voices are heard. And I wanted to ask about your advertising campaign and where you are with that and the kind of methods you're using to make sure that you're getting to the right people and you're getting as broad a spectrum of people affected by this as possible to engage them. And I just wondered if you could talk a bit more about that, please.
We're not at a stage at the moment where we have an absolutely clear advertising campaign in terms of where we intend to advertise. My understanding at the moment is what we were doing is focusing on local media in the first instance, so local newspapers, radio, possibly television, and then also looking at social media to access people in the diaspora who are impacted by the institutions and pathways and practices. We'll also be engaging in a number of events, outreach events, both locally but also particularly in GB, around Irish centres, for example. We're thinking about how we can be innovative around that and how we can reach the maximum number of individuals. It's harder to think about how you might reach North America, Australasia, for example. Outside of social media, we know that some of these individuals, particularly older individuals, will not be so active on social media, so we need to think about what particular media, what newspapers they might be reading. But it's something we're still developing at this moment in time. We have a sort of 2 or 3 months before we think we need to get this planned and finalised.
Thank you. Just in the briefing I had mentioned that May to September of this year were really key months in that, and we're obviously in towards the end of May here, and I think has been said previously on the committee, victims and survivors feel they've been waiting a very long time. So I totally understand you want to get this right, but also we want to get this and engage as many people as possible. On that, the budgetary issues you'd mentioned, does that come into the advertising campaign? And if you could maybe just talk a bit more about maybe some of the constraints that you felt and more freedoms that you'd like with around your budget, if that's okay.
So the budget is for the advertising. We're looking at £250,000 advertising budget. So the money has been there from the start. Was there from the start on day one. The issue is we're an independent panel who are operating under civil service procurement regulations and rules. So we might well ask for something and all agree on something, but then it can take what seems to us a long time before the ask is delivered. You have to go through, and it depends on the size of the ask as well, the length of the process. So one of the things that we had to do to recruit testimony facilitators was to recruit them essentially on a part-time basis, because that meant that we were asking for less money in the first instance, so we could get access to that pot of money quicker than having a bigger ask. So our second ask for the testimony facilitator wage bill, so to speak, is a much bigger ask, and we can do a lot more with that. So it's kind of issues like that have been slightly frustrating. It would have been great as co-chairs to be able to arrive on day one and have here's a £2 million kitty. How do you want to start spending this money? Not, you need, that will take you 3 months, that will be 4 months, that will be 5 months before there is a yes answer to this. So that has all been frustrating.
I think just to say on that, I do think £250,000 for an advertising campaign that you're hoping is reaching people across the diaspora in various forms of media, I think is quite limited, and hopefully we get something the committee can follow up on. So thank you.
Thank you, Patrick. I'm going to bring you in now, please.
Thanks, Chair. I'm just checking you can hear me okay.
Go ahead.
Yeah, it's just thank you firstly for your presentation. I think it's been really informative and it's been really good, especially on the back of the last one. Just to check really, I suppose, what is the relationship really between the consultative forum and then the independent panel? How do you feel that relationship's working?
You want to take that, Leanne?
Yep, I can. So I suppose whenever the independent panel was established, the consultative forum had already been established and had been consulting and working with the wider Truth Recovery programme. We have been regularly attending the consultative forum. There are, as we said, we have 3 victim survivors on the independent panel who also attend the consultative forum as well. So the experience as well, what we have tried to do as much as possible is to consult with the consultative forum too, particularly with relation to testimony. And that's where that relationship has been incredibly useful. So the information forms, the various forms that were designed for testimony went to the consultative forum, and the feedback from those really did change, quite a lot of the way in which the forms were written. So we have been really able to and to draw on a lot of those concerns. We've had one really useful face-to-face meeting in Prony, where members of the consultative forum came along and were able to be taken around Prony to see the process of really where records were being held, where they were being stored, to talk to the members of the team who are working on the digitising of the records, how they're conserved, how they're looked at. And I think that was a particularly successful event in terms of being able to really see the care and the attention that was going into those records, and for members of the consultative forum as well to ask any questions that they had directly of Prony as well. So the engagement has been close in that regard. We have also had we have an additional mailing list of people who get the information. We have a newsletter, regular newsletter as well about the independent panel. So there's communication there as well, and sort of small group sessions that have been developed too with victims and survivors there. And we're there waiting to see the process of the consultative forum has, and that's Avila and members of the consultative forum will talk more about that, I'm sure, afterwards as well. And again, it's key that the independent panel is as closely involved as possible, and is also as closely involved as possible with as wide a group of victims and survivors as possibly we can as well, to get their involvement is completely key in our processes as well.
You follow up, Padraig?
No, absolutely. And I mean, I'm just wondering, just in terms of, you've mentioned about Prony there and the record keeping as well, and that's obviously something we've continuously raised and had raised in this committee. In terms of, the questions or the queries that were brought up that day, are there any things that are still outstanding that we need to flag up that can be improved upon, or what's your views on that?
In terms of records? Sorry. Yeah, I mean, it is an ongoing process, and I think that we have in our interim report we said, and I would like to flag that there have been a number of organisations who have been incredibly cooperative, who have, and there's a very positive aspect to this as well, where a lot of organisations and institutions have engaged with Prony, where records are being digitised, and that's really it is really important, and it's to stress that as well. I mean, this point came up about the preservation of records and the possibility of destroying. A lot of records they're fragile. They're not necessarily held in archival conditions by institutions and organisations. They're in a filing cabinet or a cardboard box. They're not been held in the proper conditions. And it's really important to ensure that there is a good digital copy. And the process of digitisation is a slow one. It's about sometimes the fraying of pages. It's about making sure they're all preserved properly. It's about a quality assurance process to make sure every page has been captured as well. So I think that process was really useful again for everybody, including I think members of the independent panel, to see the process actually as well. But there are still discussions are ongoing with other institutions and organisations, and we do hope that those will be speedily resolved. There are, genuine reasons and concerns that people have, and that process is moving forward, and hopefully we will get to a situation where, we can sort of tick the box that all organisations and all institutions have cooperated with ensuring the protection and the digitisation of those records.
No, thanks for that. And I suppose it kind of comes back to the earlier points that Carol and others were making as well, just around not only is it preserving those records, but it's ensuring that records firstly aren't destroyed, and then it's about access to those records as well, because those records, people have to have access to the records that they need to get the answers that they want as well. So Thank you.
Thank you, Padraig. Carol, please.
Thank you very much. One of the questions I had, probably for yourself, Sean or Leanne, I know of women who left these shores to go to Scotland to have their babies. Is there any I didn't see any record of them here. Is there any consideration for that? I think they're dead now, to be honest. I mean, I know of at least 2 that are, and their families found out after their death. So is there anything in that? That would be my first question. The second thing is, I mean, I'm just very anxious around the public records because I had an awful experience when I was responsible for Brunei, when the state tried to prevent me, a minister, from disclosing records. And no disrespect to the religious orders, they're behaving in the same way the state did in terms of a lack of disclosure. And that's why Paula and many others have lost their patience with some of these orders. So for us, it's about, and to be honest, I'm just trying to think of the journey, Roisin, that you said that you are trying to provide a guide. If someone really is putting themselves forward to go through that journey and they meet opposition, then I don't know how to get through that, despite all the excellent support that they would have. So how can we ensure that those responsible provide the records is one question. And then what can we do to help people who years, decades later are still going through shame, guilt, and how can we get them to a place where they want to get to? And I think when you're taking a trauma-informed approach, you have to assure people that any public inquiry cannot be adversarial. It almost needs to come from a truth recovery process rather than what we've seen with RHI or whatever. So they would be my questions, because I am worried that some of the institutions will just be happy for those records to lie in a damp box in an attic somewhere, to be frank.
Just to sort of take that last point maybe first, I would say there has been, in terms of the engagement, in terms of making sure that we have got access to it, we'll never, there may well be, of course, we'll never know. Mm-hmm. What we can say is in terms of the previous research that we did, in terms of the records that we saw then, in terms of then that sort of wider, there's been a wider survey then taken to go out and to meet with all the institutions to sort of access the records. There has been, and again, you know, you can never know. I can never say we've got, but for what we've seen, I would say we're aware of all the records that are available, and that those records are being brought into Prony. There will be, there's a process, and there will have to be a process that happens, that's going to happen after the public inquiry as well. And one of the things, and Roisin might want to speak more about this, is that the Truth Recovery report as well covered was about the idea of an independent archive at the end of this. And I think, you know, that's we're in as a panel are discussing what our recommendations will be for that, but very much the purpose of that is to ensure
it does need to be independent,
exactly,
because the Irish government closed the files.
Yes,
and which is an absolute disgrace.
Absolutely,
frankly.
Yeah, and we're
so it needs to be independent of the state.
Yeah, and it's looking at, I mean, I think it's looking at best practice elsewhere. There are lots of examples out there in other countries where they have gone through similar processes, and they've done different things in terms of allowing access to records, or in terms of guiding people towards this. And I'll let Roisin speak. Would you like to speak about that sort of process?
I suppose there's two things here, Carl, from what you're saying. One is that it's not just enough to put a guide out and say, here's the legal requirements, GDPR, you know, whatever. Yeah. It's not good enough to do that, and we recognise that. Also, there's the whole thing about when people get their records and the terminology that may be used in it can actually be traumatising again, because it's maybe from 50 years ago and whatever. So there has to be an advocacy service there. There has to be advocates who will take people through that journey, first of all, and then help them interpret what they get. and be there for them whenever they get those records. So our group, our Access to Records, myself and my colleagues are working very hard on that, and we've got the first phase, which is the guide, and it's taken a while for us to get there because we wanted it to be accurate, and we wanted it to be legal, we wanted it to be proper. Then there are these other issues around advocacy, and the Executive Office have worked with VSS to actually look at providing I don't know if they mentioned it today, but an advocacy service which will be up and running quite soon. And we would like to have an input to that as the independent panel, because in some senses our remit is very narrow, and that's, I suppose, going back to some of the questions about the consultation forum. They're here today and they'll speak for themselves, but there's certain things that we don't have any, it's not in our remit at all, but this is one of them. So the advocacy is really important. It's really important that people feel that they've got somebody at their back and somebody on their side. I suppose the permanent archives, I mean, for me, it goes to that question. It doesn't answer the question that you're saying about shame and whatever. It doesn't answer it, but it goes to the question sometimes that we're actually saying there's going to be a permanent archive here to what never to do again. And a couple of us, a few of my colleagues, we've got together, and what we're looking at is we need to talk to victim survivors about that, but we need to look out there at the world and find out what is the best practice. Can we showcase for people, here's what could be the best practice, and we need to vision this, and this needs to be something really different and really innovative. It's not just about here's the room you'll go to if you want to get that ledger out, and whatever. This needs to be maybe exhibition, maybe lots of things, but we need to look other particularly in the legacy issue. People have gone through this in other countries, and we can take examples from that, and so we're doing that. And I suppose, Carol, I hear you saying as well, I suppose I'm hearing you asking what more needs to be done, and I'll step away. The independent panel haven't discussed this, so I'm saying this as an individual. But for me, it's not like my work in the voluntary sector where you have an issue or you have a geographical group of people, where it's very natural to bring people together. This is a very different thing, but there isn't any agency there. So you have the consultation forum that they'll speak for themselves. I don't need to speak for them. It speaks directly to government. Many of them are there as individuals. There isn't anywhere for people to caucus. There isn't anywhere for people to get their issues to work out. Is that your issue? Do you really think that's an important issue? Do you need whatever? There isn't anywhere to interface with that. And as I say, I'm speaking very personally here, and I think that's critical to going forward, because if you take the HIA or you take any of the other, they had commissioners or they had other things, and I'm not advocating that or not. I'm just saying there needs to be an agency or a branch. When I say agency, I don't mean a agency. I mean people need to have agency. They need to have agency in this, and that needs to be acknowledged at a government level, because that's the beginning of that peeling off, the recognition, and that's what it is. It's a recognition of, we know this wasn't your fault.
Yeah, 100%.
Carol, and it's for me, those things are really important. The permanent archive, the notion that people acknowledge what happened and that it wasn't people's fault, and take that forward. But as I say, the independent panel haven't discussed that, and I'm very, very clear about that. But I've spoken, I mean, not just the consultation forum, but I've reached out to other birth mothers through our database. And some people have come forward, and I've spoken to them, who have never got involved, because people always aren't automatically drawn to maybe, groups like that. Yeah. And I have reached out, I've spoken to people from other countries, I've spoken to people in England. And interestingly, Carol, you're saying about the Scotland thing, some people feel that they culturally went through adoption processes even though it was in another country, because the same
religious orders.
Yeah. The same conditions about what people thought of them or whatever. People feel that they had culturally, but I've spoken to women from other jurisdictions and other places, and they would love to have somewhere where they could focus. There was somewhere to focus where they could have confidentiality and know that their identities wouldn't need to be talked about or whatever, but that they could get good advice and good support.
Thank you. Harry, please.
Thank you very much, Chair. And for Roisin, that's similar to Carol's. When you mentioned the go-to guide and birth certificates, Is it a straightforward enough process, or is it very complicated? It would seem to me that the information's there, it's just not everyone has access to it. Would that be right?
I think you're right. I think the information is out there. I don't think we have a culture of helping people through this process. I suppose I better say as a personal opinion as well. We've done the go-to guide, but we're actually going to start looking in the next stage of our strategy. From the group, myself and my colleagues are going to start looking at some of these issues and start looking, what would be the best way. There still are, it's very bitty, there still are places like where do you go for court reports? Which court, where do you go? It's sort of straightforward in some ways for a birth certificate, and then you have to go through. So there isn't just you were talking earlier about the trusts, it isn't just the trusts either. There's independent adoption agencies, and they would maybe, although they would go on the guidance that you have seen, the processes may be different. And it just strikes me that it's not that easy. It's also very difficult, for example, to find out your medical records, particularly when they go back quite a bit. When you get to my age, But so it isn't as straightforward. You're absolutely right. Yeah. It isn't as straightforward, and it is about. Some people may be able to look at a guide and say, oh yeah, right, that's what I need to do, but other people may need help with that, and they may need support with that to get through that maze.
Yep, okay, thank you. Thanks.
Okay, thanks, Harry. Sinead, please.
Okay, thanks, Chair. I suppose I really want to talk about, and the last panel, the department, I asked them about the advocacy role and about perhaps an interim advocate to be appointed. What is the formal position, or have you got a position yet from the Truth and Recovery panel in relation to consideration of a dedicated person or small panel? I mean, I'm not being prescriptive at all, but like, where's the Fiona Ryan advocate for the Truth and Recovery, those that are engaged in that forum? And do you think it's required at this particular point in time, or is there more work for you to do before you bring a final report, and is that the after action? So if you have any thoughts in and around that. I know Roshan has made her thoughts, but you're saying, Roshan, that's
my personal opinion. Yeah,
but I really do want to know what the Truth and Recovery panel feel about that at this stage.
We haven't got a formal position on it, partly because it's something that came up relatively recently, I think. And we did ask Fiona Ryan, we had her visit one of our meetings recently, we did ask her the question whether she thought it was a good idea for us to suggest that potentially in this report. We could have put it in this report. But we haven't come to a final decision about that. I suppose if we're giving our personal opinions here, my own view at this point would be this is already quite a complicated space. You have the consultative forum, you have the TEO, you have the Truth Recovery Design panel, which is still in the background. You have the independent panel, public inquiry is coming down the line. There's going to be a chair of that who needs to be discovered at some point. If you then throw an interim advocate into the mix, I think you could confuse people. That would be one of my arguments. I'm not saying that I'm against the idea, and clearly if the panel decided we were going for it and we wanted to recommend it in our final report, then we will do, But I think we haven't had a full discussion really of all the pros and cons.
Do you think because there is so much going on that, the victims and survivors, and it's not a homogenous group by any stretch of the imagination, you've got adoptees, you've got mothers, it's very, very complex, and there's times that people in that are going, who do I turn to, and who is representing me and my voice in it, because not everybody feels that they can use their own voice but want to use an advocate for their voice, if you understand what I mean.
I can see exactly. That's a brilliant point and a brilliant counter argument to what I just said. I suppose one final point then is that there's just been there's a recruitment, I don't know where it is at this moment in time, for new staff who are going to be advocates and who are going to be providing these support services via Wave and Adopt NI. So again, you'd be putting somebody else into the process before those individuals were bedded in maybe and given their role, and their role was fully defined as to what they were doing, unless they're going to work alongside this new interim advocate. And again, I'm just talking off the top of my head here. This is not something we've had a big discussion about at the panel, or not a full discussion at the panel.
So I'm just looking at the recommendations about extending the panel's work remit for about 6 months, and you've outlined the reasons, and you've talked about them, the procurement and the clunkiness of it, and all of that. But a message to this committee for us to go back to the department to see what they can do to ensure that your future work is not delayed because of the same processes, because it's like where does this end in that? So from the chair's perspective, we as a committee should really go back and see what support. And then in relation to the assurances that yourself, both of you were given that in 2018 that no records existed outside Prony were inaccurate, and that has obviously slowed things down again. Now, you've spoken about it in some of your other responses. Are you assured now that there are no further records out of your reach, or because this can slow this process down again? It's just, what kind of inbuilt assurances have you got now?
Where that is an ongoing process. So at the minute, again, similar surveys that took place regarding the private records, so the records of held by institutions and organisations. A similar process is taking place with public bodies and departmental records to ensure that things haven't been missed or overlooked, or to ensure it is a complicated process, and often records, it's not necessarily clear what's in a box somewhere. There is a process that involves making sure that everything has been looked at and that we're clear about what's there. So that is an ongoing process, and that is again one of the factors that we have said that process hadn't been undertaken before we began our work. So you're always hopeful that records do appear, but also hoping that they haven't been overlooked. So I suppose it's a sort of, you're both hopeful and hoping that people have done their jobs and looking whenever they've been asked to look.
Can I ask another quick question? Why was the anatomical issue not dealt with it in this interim report?
Simply timing. We have recently met with Queen's University Belfast to discuss that issue. So it just was simply records. And again, none of the findings really that we have discussed from a lot of records that we're looking at have been included in the interim report. So that's an ongoing process.
Thank you. Just before I go on, we actually are going to be inviting Queen's later on in the year to come and talk about that issue. So Brian, please.
Okay, thank you, Chair. Just a few points. Sean, first of all, when you mentioned about private nursing homes earlier, I presume you meant in terms of victims and survivors. It wasn't about expanding the remit of your inquiry, it's just about where people would be living now, is that right?
No.
Or was there any suggestion of expanding your remit?
So private nursing homes are an example of this term, all-embracing term, pathways and practices. So, we know that some victims and survivors, so so let's say a young woman became pregnant, her family wanted her child to be given up for adoption, or somebody decided her child was going to be given up for adoption. Instead of being sent to a mother and baby institution, she might have been sent to a private nursing home for the same purpose, which was to conceal the pregnancy.
Yes, out of sight, out of mind.
Out of sight, out of mind. And so we know that those institutions were also used for the same kind of intent.
And you're trying to capture some of that experience.
We're trying to capture that experience.
Okay. Well, that's important, right? I'm glad I asked that question then, because you made a later reference to nursing homes in terms of where people might be. No.
Nursing home,
That's important to hear that. I appreciate your interim report is just published, but I presume it is formally, effectively submitted to the ministers, to the department, and we'll have opportunity to follow up on that, including your request for the early appointment of a chair for the inquiry panel. But I presume it's too early. You haven't had any response formally, I presume, or have you, to any of these requests. But anyway, we will be able to follow up as well. Roisin, you referred earlier, when I read out the bit from our report about the Magdalen laundries, the point I was wanting to make in terms of when it talked about women who were, in the wording in the report, fleeing domestic violence, and women with substance and mental health issues. These are women who deserved specialist support services, not to be literally sent away because they were seen as some sort of problem. So it is utterly appalling how they were treated instead of being given that support, to just literally be sent away. And maybe it's too early to ask you. I mean, Sean, you talked about the testimonies that you've been gathering. I don't know if you were personally involved directly in that. I don't know, can you give us any flavour? I'm not preempting what final report you could give. Can you give us any flavour of the testimonies that you have received in terms of experience people had?
I mean, people can look at the previous report, the 2021 report, and there's quite a lot of information, long excerpts from the testimonies there. So I have been involved in some of the collection this time around, and the testimonies reflect what we've been hearing, reflect some of the same themes. I mean, one powerful thing that's emerging is the kind of thing that Roisin is maybe arguing for here today, is the sense that there needs to be, the term is often used, we need a one-stop shop, and that is somewhere where individuals can go and be have the system explained to them, have the access to records process explained to them. Even they might need to be told, well, actually, unfortunately, in your case, those records don't exist, or they'll be very limited, or any other very helpful information that they can get. That's come through from quite a few of the testimonies so far. Another issue would be, the strong issue that's come through so far is adopted adults who don't know their medical histories, they don't know their family medical histories, and that's caused for some individuals severe concerns and severe problems when health issues have arisen. The doctors haven't been able to try and rule out certain things, rule in certain things. So those are some of the issues that have risen early on so far this time.
Okay, thank you.
Thank you. Emma, please.
Thank you, Chair, and thanks to the panel for your written presentation and for the questions that you've answered so far. I wanted to go back to, I suppose, around the support. I noticed something that I hadn't even thought about in the report that you provided around the sort of means testing for, I suppose, legal help, legal aid for people in the North, and the sort of almost punitive impact that could have on people now seeking help. Like, I know, Roisin, you began at the start around how an awful lot of people wouldn't even know where to begin trying to access records and getting information at this stage in their life following what has happened to them. So I wonder if you'd speak to that, because I'm getting the sense that the support maybe isn't what you would like it to be for victims and survivors, and I suppose that's an additional barrier. And I know you had said in the presentation that you had liaised with departments around trying to eradicate that, but I don't know if there's anything that we as a committee could do in that regard. And then I suppose the other question that I have, and we're seeing it even now in everything that you're saying around ensuring that particularly the women and young girls who went through these institutions at that time are told very clearly that we as a society know what happened was wrong, and that there was no wrongdoing on their part, and that it was an ill that was inflicted upon them. What that means in the current context for, RSE and for ending violence against women and girls, and all of the conversation that we're having around that. There are lessons to be learned from the past, and what your views are there.
Can I just mention, Emma, thanks for those questions. In terms of the support that is available, there is quite a good range of support available from VSS and then their partners, which is WAVE and Adopt NI. That's a health and wellbeing model, and it's a sort of a caseworker model. And I was probably talking about a separate issue, which is more about advocating on behalf of people, which is a different sort of support, I suppose. The health and wellbeing model seems to work very well, and the feedback and the consultation forum will be able to speak to this much more than I will. But from the conversations that I've had with victim survivors, that seems to work very well for people. I absolutely agree with you on your last point. I probably missed the middle one, but the last point was this is about the lessons that we learn now for strategies for women and young girls, and also around violence to women. Because if you think about it very logically, if it was all right to do what they did then, and that was the state in some senses, well then it gives out a very loud and clear message. And if we're looking to counter that message nowadays for women and young girls, it has to be about using it as an example to say, this was the dark days and this is never going to happen again and won't happen again. Did I miss something in between there, Emma? I think you did.
No, you didn't. I suppose the support or
the legal aid,
advocating for people is what I was.
Yeah. So
getting to those people who don't.
There's some people that want to go forward, for example, to get psychological counsel and talk therapy, and a whole range of issues that VSS. And there are other people that don't. They just want to find out. They just want to go back and find out what happened to them and what the records were and make sense of their lives and why this thing that happened to them very early in many times has such an impact on their life. And some of that is about talking to, talk therapy and whatever. In terms of the legal aid, so it's not that there is a small scheme available. So, for example, if someone wants to get a file and their file is either redacted or they're having difficulty getting a file, say it was a care file from an adoption agency, for example, they then can, for example, go through a whole series of stages. So they can go to the Information Commissioner, they can go for whatever. In life, really, when you think about it, and we know this from experience, if a solicitor's letter arrives in somebody's door, it has a much bigger impact than if I send a letter to to some agency, right? It's going to have a bigger impact. At the moment, the difficulty is that if people want to go to a solicitor to help them through this, some of these hoops, if they are having difficulties and they are having problems. And remember, some cases are much more complex. They're not just straightforward. It isn't just about going for your file. There have been cases, where people have had different names and different jurisdictions, and they're just not as straightforward as finding, your files through the normal ways. It's difficult because people are then means tested. And it means then that they can't get a solicitor. So our working group have written to the Department of Justice looking at to look at a way forward for this, to see if there is a way specifically for access to records if people can get legal advice, and that the means test won't be applied. Emma.
Okay. Everybody? Emma, do you want to come back in? You all right? Okay.
No, thank you.
Okay. Well, thank you so much. And great work, and please do keep us posted as you go forward. Thank you.
Thanks very much. Thank you.
Okay, members, we're going to move straight through because I think some people might have. Some people may have to leave a little bit early, so we'll just move on to our next panel. So, members, we've got representatives from the Victims and Survivors Consultation Forum. So we have the chair, Avala Kilmurray, and then we have 4 members. So we've got Paul McCleary, Patricia Mallon, Richard Michael Hadley, and Adele Johnson. So, Connie, could you open the window when you're passing? Could you open the window when you're going past? No, you're okay. Open the window when you were just passing there.
It is a wee bit.
Yeah. It's roasting, isn't it?
That's why.
It really is.
You got a cold?
No, I've had this 5 weeks. I can't get rid of the chest infection.
Aye, I've got it now.
I can hear me.
Aye. 5 weeks.
Thanks, Connie. See you later.
Are you going to save it?
I got antibiotics now.
Did you get a chest x-ray?
No.
Appreciate.
Google I usually go to, which is the worst thing.
Okay, everyone, thank you for waiting. Obviously, with two meaty panels there, and we're really looking forward to hearing what you have to say now. So, Avala, do you want to make some opening remarks?
Okay, yes, thank you very much, Chair, and thank you for introducing our panel. I'm just going to say a few remarks about the consultative forum. and then hand over to people that have the lived experience, basically. I became independent chair in April 19... It sounds like 2022. I took this role on a voluntary basis because I was very conscious just about the level of mistrust that people have in the system, because essentially many of the members of the panel will talk about just being lied to by various professionals over years and years and years. And I think the point that Roisin made is really important about re-injecting a sense of agency and empowerment into victims and survivors themselves, because they are the ones that really have the answers and know what the issues are. So our forum membership, as was mentioned earlier, is between about 15 and 25 on a monthly basis. Unfortunately, it has to be by Zoom, which has its drawbacks, because it's hard to get that sort of personal engagement. But we have a very diverse sort of geographic spread. But we also have a very diverse composition in terms of people that are birth mothers, people that were adopted, people that are family members, relatives. So quite often we will have also a diverse range of issues coming up, and indeed suggestions coming forward. The TO has acted as was mentioned earlier on, as our secretariat, and in drawing up the agendas and circulating very detailed minutes. And that is because they do go out to about 90 other people that have asked to be going on the list. There is an issue, however, and in fairness, I must say that in terms of the civil servants that we've had, they have been under pressure as well. And particularly, I must say, pay tribute to Pauline Cuscadden, who has been with us as long as I've been involved with the independent panel, who is available at the end of the phone well outside office hours. However, there is also an issue between a civil service culture that is hierarchical and is bound by data protection. For example, I as chair do not have access to the emails of the members of the panel. It has to go up to the department and sort of down again. And that's sort of an issue when you're trying to actually draw something together. And it actually, I think, goes back to the point that was discussed in the last session, and that is the need for something to actually to allow victims and survivors to come together themselves, because the panel meetings the forum meetings are really important as that interface with the civil service and departments, but people need time to actually work through what are their priorities, what are their demands, and if need be, and we have been asked at different times, to retain their own legal advice, because again they're being presented with very complicated pieces of documentation, and it's very dependent really then on the input from the various government departments. So I think there is a need there. Having said which, I mean, there has been progress. There certainly was progress in terms of the guidance and the access to records. And where there was progress, actually, it was where you had subcommittees with some of the officials and some of the victims and survivors themselves. But they're not always in place, and they don't always operate. There was obviously progress in terms of the independent panel. But increasingly, and I think particularly, and on this I'm going to hand over to our other representatives here, increasingly I think there's a feeling that as we are moving into a situation of legislation, of provision for the public inquiry, that people are getting more and more disempowered because decisions are sort of being made up here. And whenever there are questions or requests for further information, the references back to ministerial decisions or the possibility of judicial conflict of interest or whatever else. So there is issues there. However, I think that the idea behind the integrated truth approach, which could be non-adversarial, was really important. The question is, once you then get into a public inquiry, will that work in practice, basically? And one of the things that I clicked in my brain when I heard the infected blood report coming out is the statutory duty of candour. We actually need a statutory duty of candour, whether it's in terms of access to records or who's holding the records, or what sort of process is going to take place in terms of the public inquiry. So I'll just leave it there, and perhaps if I could hand over to Adele.
Good afternoon. Thank you very much for listening to us today. My name is Adele Johnson, and I was born to a single parent in 1951. She was in Mater Dei in Belfast. I was then adopted when I was almost 2. At the age of 18, I was, I'll say, forcibly placed in Marion Vale in Newry, where I gave birth to a son. But I'm not going to here to tell sad stories. I'm actually going to discuss the access to records and the absolutely ongoing problems that people are facing on a daily basis. They're being blocked at every turn. I'd like to give you, for instance, if you don't mind, I'm helping to support a gentleman whose grandmother was in Thorndale. She gave birth to a son who was this man's father. He was subsequently adopted, and he went on to marry and have a family, but they are all deceased. He has tried to get access to his information and has been told that because he is not the adopted person, he cannot access all this information. I do understand under GDPR there has to be a protection and a duty of care, but if everybody is deceased, who are they protecting? There's no need to infantile us. We're not children. We don't need to be protected from our information, and we need to know that information. I also help support another lady whose mother came up from the south of Ireland and had her baby in Marion Vale in Newry. Her baby was subsequently adopted to the south. She has applied for information and again been rejected and sent back to Tuzla. She's not looking information about her sibling because she has met her sibling. She knows who she is. She's met her. They've conversed. They meet for coffee. They send cards. So, again, who is being protected in that instance? There's no need for safeguarding. I think people need to keep in mind that we are human beings. We're not numbers on a spreadsheet. Can you imagine going to the doctors and the doctor said to you, have you any history of heart disease? Have you any history of diabetes in your family? And you look rather blankly and you say, I don't know, I'm adopted. Genealogy is also quite a nice thing people are doing. They're looking up their family trees. Adopted children can't do that because we don't have a family tree. We can look to the family tree of our adopted parents, but that's not your family tree. And, you know, it just goes on and on. Simple things that really frustrate, upset and hurt. We're human beings. We bleed when we're cut. So thanks very much for listening to me today. Thank you.
Thank you, Adele. Richard, Mike.
I think we're going to go over to we've got a bit of a running order. So,
okay, go ahead, Paul. Thank you.
I'd like to start by declaring an interest, if that's okay. So I am also a victim and survivor representative on the independent panel, but I'm here today speaking in my capacity as a victim and survivor and to represent the views of other victims and survivors on the consultative forum. I had an opportunity before, along with Adele and 2 others, to present to this committee, and I see some members here who were there 2 years ago. It was a very powerful day, and that day we talked about our lived experience, so I don't intend to go into the depths of that today, but what I would say is that was 2 years ago, and we've taken a few baby steps, but really not much, unfortunately, has happened for us in the last 2 years, and I accept, and we accept, that government has been down and there are issues, but as a victim and survivor, there are issues in our lives every single day, and they will always remain with us. So we're actively seeking truth and justice swiftly. I'd like to start by saying what a privilege it is to be able to speak on behalf of victims and survivors today. They have shown incredible resilience in their pursuit of truth and justice, not only for themselves as individuals dealing with the legacy of trauma every single day of their lives, but with the weight on their shoulders, the civic responsibility for others, thousands out there who have yet to come forward
into this process. The engagement is too small. After 30 meetings in 2.5 years since the publication of the Truth Acknowledgement and Accountability Report in October 2021, the fact that so many are still unaware of the process is shocking, and it's a failure of conscience. Richard, whenever he speaks, we'll talk in more detail about that. I'd like to talk specifically about concerns victims and survivors have around one of the 5 core recommendations, and that's recommendation number 5, redress, repatriation and compensation. And forum members, when we engaged with them before we came here today, voiced some of their concerns and asked us to bring them to your attention. They strongly believe that redress, repatriation and compensation is as much a matter of acknowledging the wrongs done as it is about financial compensation. I think that's really important. They've reflected deep hurt over the posthumous date that we've heard about in proposed legislation at one of our consultation forums. You talked about that earlier on. And I noted when the TAO gave evidence, they said that within the Truth Recovery Report, there actually is no paragraph, no words that talk about posthumous. But there is a paragraph in there, and I'd like to read that paragraph to you. And it says, a financial redress scheme should be prioritised, comprising an automatic standardised payment and the entitlement to a further individually assessed payment. The scheme should include all women who spent time or gave birth in a mother and baby institution, Magdalen laundry, workhouse, or related institutions such as private nursing homes, and all those born to girls and women while institutionalised. For us, as victims and survivors, there's your reference to posthumous right there. We strongly feel that the setting of a date must not exclude large cohorts of birth mothers and their family members. Victims and survivors have been silenced for far too long, and further exclusion is completely unacceptable. And they also have further concerns around the inclusion in any redress scheme of children born, or the lack of inclusion, in any proposed redress scheme to children born to mothers in workhouses or Magdalen laundries. That appears to be absent. On the issue specifically of posthumous claims, we have been told that the date, November 21st, which was around the date that the First and Deputy First Minister at that time accepted in full the 77 recommendations that were included in the report, the Truth Recovery Acknowledgement Report. And that date's been used as the entry point in terms of eligibility for redress. That date's not acceptable for us. That date leaves too many people behind. That date for me, I was a child, a baby in one of these institutions. I'm now an adult. I left there when I was 18 days old, and I've never and will never see my mother again because she died when she was 29 years old. And I've talked about that lived experience. But that date says to me that her life didn't matter. That date says to other victims and survivors, to the loved ones that they have lost, the family members, children, mothers, that their lives didn't matter. And their lives absolutely do matter. We were told that the advancement of this date, and I heard TO officials talk about this today, that they based this on similar schemes. And one of the schemes they based that on was the scheme that's recently been launched in the Republic of Ireland. A scheme that continues to come under scrutiny from victims and survivors, academics, TDs and interested stakeholders. A scheme with the single swipe of a pen that removed 24,000 children, now adults, from redress, citing unless they spent 6 months in an institution, they are ineligible. And that takes no account of the lifelong effects of separation and abandonment and the complex PTSD that those individuals have suffered. To suggest to us that a scheme like this should form a benchmark for the posthumous or proposed redress legislation, that's frankly insulting. That's not a world-class scheme. That's the very thing you should do, is look at that scheme and say, that's not working, let's do something different. So it's disingenuous at best, in my view. This is not about money, and I've already talked about that. It's an acknowledgement that the people who have gone before and are sadly no longer with us, that their lives matter. And not having a form of this addressed in a posthumous date is wrong, and I accept it can be complex to work all of these things, but I can tell you, living every day as a victim and survivor is complex. That's difficult. Sorting out some legislation or how we might administer a scheme, yeah, that's difficult. But living every day as a victim and survivor, that's what's really difficult here. Other members of the forum have concerns that memorialisation and action on this should be taken forward without delay. I think I'd like to spend a couple of minutes talking about co-design, and in particular how this concept is delivered in practice, because we're told we're in a co-design process. But when it comes to any proposed legislation, we feel we've lost agency, and we are not truly in a co-design process. So the recent proposals around legislation that's been drafted around redress scheme and the public inquiry, we've had sight, we've been listened to, but I don't believe we have been heard, and our concerns have been heard. And it seems to me there are times when co-design can be used, and times when co-design is simply thrown out of the window. And we're told there are elements of this process that are not suitable for co-design, and influence on proposed legislation is one of those times that co-design doesn't work. As stakeholders, we find that notion incredible. This is our truth and justice. To diminish us and say that we are a stakeholder who might have bias or advantage, again, I'm afraid that's insulting. We should have influence, and we are being denied influence. We should have agency, and we are being denied agency. And these are really important things that we would like you, on our behalf, to address with TEO and other officials. I think I'd just like to finish by saying I'm going to quote the lyrics of an Elton John song.
Great.
I'm not going to sing it, I'm just going to quote it. And the lyrics of that song are, sorry seems to be the hardest word. In this process, when it comes to redress, so far, sorry seems to be the only word. Sorry's not enough. Sorry alone doesn't deliver truth and justice. And we need urgent action in terms of payment for the acknowledgement part of redress. Sadly, many of our community are advanced in years, and they won't see the public inquiry. Mm-hmm. They won't be here when the individually assessed payment part of the redress scheme and the redress board are here. So they require help and assistance, and they require that element of truth and justice now. So we would urge you to continue to support us in our pursuit of truth and justice. I think, Patricia? Yeah?
I don't know if it's imposter syndrome, but I feel I shouldn't be here. And the reason is that I know a bit about Magdalen Laundries because I was in Sacred Heart Home, which is adjacent to that up the Ormer Road. I was there with my sister, and inexplicably to me, she wasn't there and she was in the laundry. So I'm able to give a testimony from the point of view of a sort of an observer, but I understand that it's not in your remit children's home, but you can't divorce the two, and that's part of the complexity. I knew nothing whatsoever about the mother and baby home. I could see it from the dormitory window over the wall, but everybody acted as if it didn't exist. And I think that is a measure of the shame, the stigma. But being on the fore, I mean, I just got involved because I thought, well, I know a bit about that place, and I went to Queen's and said, do you want to know the bits I know? And it turned out to be a bit useful. But as I say, I feel I haven't suffered in the way. I can't imagine anything worse than being coerced and giving your baby up. I think everybody would agree with that. From that perspective, I think younger people, maybe because society has moved on a bit and values have changed quite a bit, I think it's hard for them to imagine what it was like and how. I mean, if it weren't of the shame and the stigma and the a culture of secrecy, really. Yeah. I mean, there were family breakdowns, but the most important thing was to have a front, as if everything was all right. There was a mention earlier of the pathways into the institutions, and that's all connected with that culture of that time. In my case, I illustrate, I suppose, domestic abuse. There wasn't even the concept of domestic abuse. I came home one day and my mother wasn't there, and I knew why she wasn't there. Our father was pretty brutal. I loved him, but he was brutal. And one way or another, my sister was put into a children's home, and then in the end I couldn't take the violence at home, and I walked into the home. And I can't say they treated me badly at all. I was glad to be away from the fear of being beaten. The reason I'm highlighting this is to let you know of the different kinds of pathways, and that you can't just look at the institutions in isolation. You have to look at what was it fed them, what was it either looked the other way or was complicit in it, or were just doing their job. I would say people in welfare positions like social workers were doing their job. The shame connected with, I think a home breaking down or anything unpleasant, it was like a dumping ground. And I actually think it must be very difficult to get information certainly about the Magdalen Laundry that I knew, because in our case, I don't think the nuns treated you badly. I think it's instructive to look at the south, where you had people who were in Magdalen Laundries who were much more active and broke the silence and things, just as Adele and her colleagues did up here. But I also think it's instructive to think of the McAleese report, which was rightly criticised. But one particular thing I actually, I suppose I need to see the wording, but I don't think it was worthy of criticism, because I don't see how you could explain how these institutions sustained without thinking about society. I mean, I think they were criticised for saying society's to blame. In other words, nobody's to blame, we're all to blame. I'm hoping that the outcome of the public inquiry, the independent inquiry, and the outcome ultimately in the end will also say to the public, you're not looking at problems in your home, at looking the other way when you heard a neighbour being beaten, which was happened in my case. Those are the things, and you taking a certain attitude to somebody that isn't married, has a baby. That just was wrong, because it was to do with attitudes, and I think unless the public know that, they will be saying, oh, it was those bad nuns, or it was in that workhouse or whatever. And I think people, yes, you have to identify individuals, but I think also there's a big lot of this report is going to highlight what was wrong systematically, with systems. As I say, I think it's going to be difficult for upcoming generations to understand how this was allowed to happen, particularly in relation to mothers and children. I mean,
if you read the research, you know, they're highlighting things I didn't even know about, which, you know, families, the mother might know that the young woman was away having a baby. And in some cases, it was a result of incest and a result of rape for people under. I mean, I did, although the mother and baby home near me wasn't, there wasn't any talk about it because you just knew you didn't mention it. But I do remember a nun whispering to another, there's a 13-year-old in there now. She was shocked, but it shows you that's the sort of, so everything that was problematic seems to say a lot of social problems seems to have been finding space here one way or another. And then of course you have the fact that people who were in the laundry didn't have the status of employees, as I understand it. And I often wonder, you know, were their stamps paid? I very much doubt if they were their insurance stamps paid. So what happens to them in retirement? You know, I think that bears looking at. But anyway, when I was listening today, I was thinking I'm not as downbeat as you are, Paul. I actually think a lot of things are going right, but it definitely sounds as if it's sluggish, terribly sluggish. And for those that want practical, there are practical. See, I divide into sort of practical things and psychological and emotional things that need help with. But I think with the practical things, please let's get on with the practical things, such a suggestion. I mean, earlier on it was mentioned about there was no discretion about looking for means testing people who are looking for legal advice and assistance. That's been mentioned a few times. I mean, that would require in the independent inquiry interim review. I hadn't known that myself, and I think that's one thing that as a stroke should be fixed up. If it says the remedy is to review and amend the legislation so that victims can have access to legal aid assistance when they are looking for access to records on that specific thing. Now, there can't be it won't cost a lot. There can't be a huge number that that are looking for that. But I think at a stroke you could actually really help with that. The other thing is, it was also recommended, and we are totally behind it, where there was the recommendation of the independent panel to appoint a chair, get ahead of appointing a chair. We need to advance that for all the reasons that were mentioned. I mean, Sean has explained, didn't he, how certain things were held up at the beginning because of this or that not in place and whatever. And it is an integrated approach. So in the integrated approach, the independent panel are going to help identify questions and help. They would be, I'm not saying influential, they're independent, but a lot of the stuff they have gathered will obviously have bearing and will be fed into the inquiry. So it seems absolutely a no-brainer to me not to appoint the chair before you appoint the rest of the panel. It's even, in civil service terms, value for money, because if you appoint everybody at once, then you don't have all the nuts and bolts in place. And once that chair is in place, they take ownership of it and get a sense of what's happening. I just think it will accelerate what happens. So we definitely are completely behind them in that. And I think that's me.
Okay,
thank you very much.
Thank you.
Good afternoon, everyone. I was going to talk about the forum and just acknowledging that the length of time it's taken for us to come in front of you, and we hope it's an ongoing process of dialogue, that we are the ones with lived experience, and I know that there's lots of different strands for your constituency work and people being able to come to you, but actually the forum is the only place where we could all come together and actually navigate the issues and the difficulties and contradictions that there may be. And also, for one of the many features of this process is that lots of us have moved away because it's too difficult to be here. And this is the only place where we can actually feed into those democratic processes informally. And that does create a difference and a difficulty. So just to highlight to that we're really glad to be here and continue to be here. And hopefully we're here a lot more. The other one I want to talk about is language and about communication. There has been no real communication strategy enacted yet. I know we've talked about that already. We are limited in number, and it is hard to be in forum because we're there for the most difficult thing that has ever happened to us or people that we love. And we need to be able to steady ourselves for the long process ahead. So we need more numbers to do that. And so there needs to be a proper communication strategy to reach out. The people who are there waiting, or the people who are there, one of the other aspects of this is because of the shame, because of the indifference if you were a baby, that you have to get over a barrier that's been placed in yourself, and also the barriers that exist outside you, so it takes time to do that if you're ever ready. So the earlier the communication is done, to let the landscape of all the things that are being done, not just one individual piece of it, that it's fragmented, but someone taking ownership of the overall truth recovery programme and communicating that, one, to the population here, but also to the diaspora, and how to do that is really, really, really important for us. A bit about language. I was really pleased that the panel was able to take up some of the officials who've been with us all along, but are still using inappropriate language, and it's difficult, and it's an ongoing process, and we have to sort of keep them up on that. But also not just the indignity of language as it's used, but actually the precise meaning of it and what it means for scope. It's been touched on already by some questions, but in my own personal story, if I read the mother and baby home, Magdalen laundries and workhouses, I'm not included in that. If you include them pathways and practices, the interpretation of that is it's the pathways and practices just of those mother and baby homes. There are people out there who were diverted from those places and kept out of those places in very sinister stories, but by the same individuals and organisations that were how they were operating. And if you exclude that from the detail and legal text of legislation and of for redress and for statutory inquiry, you will disenfranchise us, and we will have to carry on another campaign. I think it needs to be reminded that why we're here 10 years later after HIA is because people were left out. You had mothers who were left out. You also had toddlers and babies, the most vulnerable people in those places, who were left out. And we're still looking to have redress and our issues addressed. And we can't be in this situation where we're going to do that again by improper use of language or of scope. And the last one is an appeal to everyone, is don't see us as babies. See us as people who have had our identity stripped from us, who have to have everyone who we ever knew or would recognise taken from us. And the silence and the daily difficulties that causes each one of us. You've heard about the indignities and the processes that it does. Then when you start to look today and go back to find out what actually happened, you find out about the impropriety, you find out about the violence, you find out about the neglect, you find out about the abuse. And that'll be something that'll be ongoing for people who are not necessarily ready yet to do that, but come years down the line and are looking for the records and dealing with those stories when they come to them, as well as the normal detail of the lives that they've missed and the families that they're no longer with, all the highs and lows of a life, many lives dumped on you at once, is really hard to take. And that's the difficulty of any adoptee, but it's more difficult when you have the other issues that are involved in what happened to us.
Okay.
So, thank you.
Thank you. Well, thank you so much. I don't necessarily have that many questions per se, but I just want to give reassurance, particularly to Paul. So we haven't seen the draft bill. We only got the letter from the Executive Office last week to say they launched their legislative programme. But we will be the scrutiny committee for that, and we will be putting out a call for evidence, and we will be, hopefully we'll not keep dragging you back too much, but we will certainly appreciate as much engagement as you are willing to give to us in terms of how we could possibly even put our own committee amendments in, or how we as a party could put amendments in and stuff, so that we get the legislation right. So I give that commitment to you today, that we will continue to engage with you in that space. Certainly the whole issue about the posthumous, I mean, the date is just, it's just so unpalatable to certainly to Connie and myself and the Alliance Party. So I don't think you said anything that we don't disagree with today, and we'll certainly be supporting you on that. I just want one question, and again, sorry to focus on Paul, and it's around the redress. And when we had victims and survivors from historical institutional abuse, childhood abuse, they were saying that it was really important that they saw the institutions making a contribution, because in some ways that was holding them accountable. To what degree could the same be said for yourselves? Maybe others will want to come in.
Yeah, I'm sure the others will come in, but we absolutely
100%.
100% agree. It falls on them, but unfortunately, not just them. The state were complicit here too, in what happened. But absolutely, the religious orders need to stop selling land for luxury flats and all of the shenanigans and burying bits and bobs that they're doing, and ante-up 100%. Shouldn't be on the taxpayer.
Okay. Carol, I'm going to bring you in now because we have to leave at 1:45.
Yeah, so thank you very much. So, Avla, I want to explore the comment that you made at the start about the way culture and practice of the civil service. I mean, I just think it's crazy biscuits that you don't have at all any contact with everybody else in that database. I mean, so if you're starting off like that, that's not a good omen. So I mean, maybe if we could agree at the end, right, so just to assure you of that. I wasn't on the last committee, so I did read the reports, and I've read these reports, but in terms of the pathways and practices, you need to let us know what they are, because the last thing any of us want to do is to leave anybody out. And I think we're all very genuine about that. And I also think that it's also part of the acknowledgement. It's really, really important for that. You know, like I looked through the report, and there's some of those institutions were in North Belfast, but what it didn't mention was the private hospital in the Mater. And it didn't mention the fact that midwives deliver babies in homes and they were never seen again. I know that. I mean, I grew up hearing those stories, albeit years later. So if that is what you're referring to, and if I've left something else out, just let us know. But it's just to assure you that we have just received notice of a legislative list coming forward. Whatever is in the legislation, it can always be amended. And for us, our ability to scrutinise and to amend. But one thing I still cannot, and I'll finish and just get my head around, is why you need to engage legal aid to get access to your records. I don't get that at all.
No.
I honestly don't. And I just think it's another impediment. So maybe that's something that could be done now.
To the poorest people.
But it's always poorest people who suffer the most. And there's a class issue here as well.
Yeah, and it's one of the reasons why I was sort of saying one of the gaps, and it goes back to the extent what Roisin was saying. Yes, there's a gap around advocacy, but there's actually a gap about, I like you had Savia with the historic. Yeah. There's nothing really that is resourced for the victims and survivors to sort of say, okay, we're faced with a piece of draft legislation. We'd really love to get somebody in who can give us a bit of advice around that. That's independent from the civil service. So just to give that additional support.
That's where the agency starts to get unpicked, because there's references there to Victim Support Service and to WAVE. They're great organisations.
It's different.
But it's completely different. Yeah. And I just find it's a bit patronising. So I'll just leave it at that.
Thank you. Sinead?
Okay, thank you, Chair. It's 2 years and 8 months since the 77 recommendations, and things have, there's processes that have been put in place, and we have to acknowledge that, and we have to acknowledge that people are doing really good work and are trying to move this forward, but we also have to acknowledge it's not really going quick enough. And we have to acknowledge that we're working with victims and survivors that are getting older, and it's not about the monetary compensation, although that's very important. It's about an acknowledgement of the hurt done to them by church and state, and many of the there's many things that we don't know as well. The undercover stuff that'll never be uncovered. Babies that went to America and elsewhere, and money crossing hands and all of that. There's really no deep acknowledgement of the church, of the undercover stuff that actually did take place as well, and we do know that. But the longer we leave this, the more difficult it is to recover it. And so I want to kind of ask a little bit just about the forum now at the minute, and you're engaged with it, because we need to make sure that it's working for you. And if it isn't, we can do something about that now. You know, we can start engaging with the department in and around that. How are the relationships in the forum? And then just a wee step on about legal support. I mean, it shouldn't be legal aid, it should be legal support, independent legal support that is accessible to you, that you are not going through the civil service to get it. This is your legal support that is available, and it's confidential, and it too is independent, and you can take it or leave it or seek other legal support, as you know, if you think you can, if you don't like that answer, or you want to engage with it in another way. So, and I think that should be something that is very possible as one of the support services. You know, we're talking about psychological support, why not legal support? In that concept as well. And the other aspect of it is, I have been engaging with victims and survivors, and they have told me that sometimes the forum re-traumatises them in a way, because it's talking about the end game in terms of redress, you know, an interim payment and then an assessment payment, and this is really throwing them into absolutely more and more trauma. And I just want to understand, is the forum working for everybody, and have you any suggestions how it might work better? I don't know, maybe that's too complicated, but
I'll start off on that, and then I'm sure people will come in. I mean, it's not. I mean, it's important to keep it there as an interface with knowing what's going on in terms of the various government departments. But it's been asked to basically co-design sort of some of the recommendations, or the responses to these recommendations. And then in some situations there has been a bit of co-design, like with the access to records. In a lot of others there hasn't, because we're told that it wasn't appropriate, that bit.
Consultation.
Yeah, there's a consultation. And then also then, as you say, you know, I mean, I've talked to people and sort of say, look, come along to the forum. But I've stopped actually doing it, because actually what they want is somebody that's been through the process to sit down with them. And they want to get angry, and they want to cry, and they, you know, and to throw them then into trying to discuss a draft piece of legislation, it's just that just doesn't work, basically, you know. So it still needs to be there, but it needs to have a much clearer remit, and there needs to be organisational support around it. And on the timing thing, and we have lost people because they've just sort of said, look, it's like watching paint dry, you know. So and they just, and we've also lost people, as Richard says, if they don't see themselves in the sort of the pathways. They sort of say, look, we're out of here. So what we almost need is a matrix of saying, these are the issues, these are the bits that we know about, you know, in terms of that are, inverted commas, almost easier to deal with. You know, if it's payment, standardised payment to people that have been through a certain institution. But these are the ones that need more research or need more thought. And that goes along. You don't wait until you've fixed one bit to start looking at something else. You do it alongside it.
Yeah.
You know. Yeah. So, for example, yes, we're being told the workhouses, there's a lot of people in different circumstances in workhouses. How do we identify which would fall within the redress scheme? Well, that needs to be researched now, rather than waiting and people feeling we're being left outside because it's too complicated.
Yeah.
One thing I would add is that everyone, as it's the rock face, it's really difficult to be there, but I don't think anyone would want it to go away, because it's so important to be there where decisions were being made, and the work of the TAO and the Executive Office, you know, we're able to affect it there. But it has been too difficult, and from all different groups and individuals have been saying for a good long time that it's been very, very difficult. Yeah. And we're grateful that Avila was brought on, and now there's been additional sort of support, but that needs to be ramped up quickly to be able to do something else to sort of bolster us as a group. A diverse group, we're not just one amorphous blob. We have contradictions and difficulties between us, and very, very different stories that we can't speak to. Not one person can speak to all the harms that are being addressed here. And so we need space to be able to work through that, and then come to the TAO with more reasoned, balanced priorities as well, because it seems to be there's a series of arrows get fired at them. And that's difficult for the individuals of the TAO as well. really difficult. But we certainly see the absolute value in it and the integrated approach. It's fundamental. I think co-design has been another thing of language of what that actually means. I think at its basis it needs active listening, and that's not necessarily what happens. The meetings are more business-like and presentations, and then they wait. There's not really much active questioning about what is the diversity of views from victims and survivors. It's more presented of, this is the work we've done, respond. There's no mere leading questions and things like that go on, and that can be quite frustrating, because then that means you feel as if you have to get across absolutely everything in a very forceful way to be heard amongst the maelstrom from everyone else. So that makes it difficult.
Richard, can I ask you and the panel, I've asked every panel that's been here today about a dedicated advocate for yourselves. What is your feeling about that?
I think it's complicated because it's not one issue. It's difficult to sort of say an absolute yes. We do need something that a focus full time that is focused on just representing and articulating the views of victims, survivors. It's how that function is going to happen, and how they're going to be able to engage with the numbers of groups and individuals that they need to, and as well then be able to present that in a way which is representative and clear, and that everyone can feel as if they're being, their views are being represented. But absolutely yes, I think there needs to be more for the forum to stand by itself rather than just being shuttled between different committees or themes as suits. Government needs to work at a certain rate and a certain way. That isn't how we think and what's in our minds. We need to be able, our own space, to be able to set out our own priorities and ways and appropriate times to go through things, and have enough time to be able to comprehend them and design the ways of doing that, rather than what may be happening with the hard work that's going on out here and is necessary. It's sort of more a better interface between the two.
Okay, thank you.
Could I make a comment, Sinead, just on the notion that I think I picked you up correctly when you talked about independent legal advice for the forum. I assume that was that.
Victims and survivors is
Yeah.
one of your services.
Access to records, for example.
Specifically for the forum, because we have asked before for independent legal advice, and we've been told that's not possible. So whenever the TEO have come with a proposition and they've taken legal advice on it, we have asked, can we have legal advice as well and a legal opinion? And they have told us it's not possible. So I think that would be very welcome from victims and survivors, that we have independent legal advice to challenge that, because essentially there's a trust issue here. And I acknowledge that TEO have made progress, but in a different guise many years ago. The state sat over this when it happened. They let it happen. So for us as victims and survivors, that trust issue is still there. And when we hear things like, well, sure, if it goes to public consultation, you'll have an opportunity to influence that. We're kind of thinking, well, why can our views not be in the public consultation before it goes? Because frankly, we think when it comes back, you'll ignore that to, suit your own agenda. So if that was something that was available, I think that would be very welcome for victims and survivors to have that independent legal advice.
The point is, you're not a stakeholder in this. You're not an outside body that needs to be consulted.
Yeah. I'm going to move on, guys. I've got
Sorry,
two more to
I
come in.
need to go.
Podrick, please go ahead.
Thank you very much.
Go ahead.
Thank you, Chair. And look, thank you all for your presentation today. I think for me, the most striking thing about all of what you've said is really that, and I just think, I suppose I know we've already mentioned it a few times, Chair, but I'm just hoping maybe we could formalise it. I think your voices, need to be heard first in terms of our committee, because our role is as a scrutiny committee. And there are a lot of things that you've said today I think that are just vital to our work and to allow us to do our role in terms of scrutiny, to allow us to understand and actually ask more pertinent questions, when officials are in, when bodies are in, to allow us to get the answers and to assist you in doing that. So I suppose it's not really a question, it's more a comment about that, and I'm hoping maybe to get other colleagues on board with that as well, because for me, your presentation has been so useful, and like I said in the committee the last time, just at the very end from 21 to 22, and I always think that hearing firsthand it is the most important thing, but to me it needs to come just first at the start of our committee to allow us to ask questions, to ask the relevant questions, the most pertinent questions in it. So thank you again for presenting today. I really appreciate all that you've done.
Okay, Patrick, does somebody want to respond to that, or all good? Okay.
Sorry, can I just say
yes.
Thank you for your words of encouragement, and can also say the fact that the First Minister and the Deputy First Minister accepted the whole 78 recommendations, it uplifted me for that one day anyway. So that's why this is all happening, because then when the government was down, we were able to continue. So to see you all together, so interested, does my heart good.
Oh, thank you. That's
Really
a nice note to end on. But thank you, and I say, once we get the bill, I would say it'll probably be consulted. Probably the autumn you'll be back, but we'd really appreciate your engagement at that time.
Thank you very much for having us. And just could I just say, when we talked to the other people that are on the forum about this this hearing, one of the things that everybody said was, look, our main concern is that we do a service for all the victims of violence. And we heard before about just the numbers, and just even to start thinking now, whatever, and Richard mentioned about communications, but it's also doing the research. What are the networks that will reach people? Because there has been things that have happened in Canada and Australia, but we need to start doing that now, because it'll take time, and we don't have much time.
Can I add something to that
Please, go ahead.
conversation? There's been a great emphasis on internet, on websites, etc., but that isn't reaching the people that concern me. I'm thinking of wee Mary lives in Fermanagh, doesn't have a phone, doesn't have internet. How do we reach her? And we've been talking about this for years. I have asked repeatedly for a designated phone line where people can phone up and be signposted towards WAVE, towards VSS, towards information to getting their birth certificates. Have it like a one-stop shop. And I know it probably needs a lot of funding, but surely to goodness you could fund a phone line.
Okay, we'll pick that up. Okay, thanks again, everyone. Thank you. Okay, members, I'm just going to wrap up the meeting now. Just to thanks again. So, in terms of our draft forward work programme, there you find it on page 100. I think we had a conversation earlier about potentially moving things about, but we'll take that offline. Correspondence, page 111 of your packet, and page 11 of your table pack. Any members want to note anything, or no? Okay. Okay. Any other business, members? No. Okay, thank you. That's the end of the meeting. Next meeting is next Wednesday, 6th of June at 2 p.m. in this room. Thank you.
Okay.